Can you hear me now? Can you hear me now? Jesus. Still no sound? Can you hear me? Okay. I did the plug in, plug out thingy, and now it works. It happened yesterday too when I did the video. I had to plug in and stuff. Okay. No? Can you ask if I can hear you now? Yeah. Okay. Yep. All right. George late again, as per usual, but he is there. I just thought I would say hello to everybody. Thank you for being here. I will also have some updates on what happened this weekend with the murder of Ty, allegedly in an apartment that belongs to Woody, but there are conflicting things about it. But first, let's go to I almost said the crime scene, but it more or less is the courtroom. All right. So let's hear what he has to say this morning if they bring this up.
Be seated. All right, ladies and gentlemen, we are back. Let's see. We're back on the record in the matter of the state of Georgia versus Khalif Adams et al. In 22 SC 183572. I'm going to go ahead and take roll for the morning here. Let's see. Mr. Stilwell, Mr. Botts, and Mr. Shard. Good morning, gentlemen. All right, Mr. Williams, Mr. Steele, and Miss Halterwinger. Is Mr. Adams going to be with us today, sir?
Thank you,
Okay,
AKA right. The cat lady.
Okay, we have Mr. Kendrick and Mr. Weinstein. Mr. Ewing, Mr. Matthews, Jr. and Senior. All right, Mr. Nichols, Mr. Harvey, and Mr. Garner. Is Mr. Youssef over there in the corner? Okay, all right, okay, thank you. Mr. Ryan and Mr. Williams. All right, good morning. Miss Hilton, flying solo today?
Flying solo.
Okay, all right, okay. All right, good morning, madam. All right. Councils, we're trying to deal with some video issues that we're still having from Zoom, but that's part of the ancillary matter. The court is going to talk with you about the release of the transcript. I have an order that I'm still working my way through, so it will be probably less than an hour. I'll come back, just wanted to put this on the record and put you all at ease, and then we'll go ahead and we'll cover that, okay? All right, so we'll be in recess about an hour or thereabouts. All right? All right, we're in recess. See y'all about 10:30, 10:35.
Of course. Now, what the judge seems to keep doing here is he really doesn't want to release the entirety of that transcript, even though it's clear now from the Georgia Supreme Court that he should be nowhere near that transcript. Another judge should be. But the writ of mandamus is now in the Fulton County Superior Court. It is assigned to another judge already. Judge, I had it here a second ago. Let's see, it's to Judge Edwards, Belinda F. Edwards. This is her. This is Judge Belinda Edwards in the Fulton County Superior Court. Yeah, John Communion, 6 months. Where had the time gone? Well, this trial. Thank you for supporting my channel, John. Thank you so much. So, the writ of mandamus is handed to her. See, you can see that. See here. case number, Diamante Kendrick versus Euro Glanville. And here you have it. Case status open. So we just have to wait and see what she does with this, because she has to come to a conclusion. We don't know when at all. So let's hope that, but it is a writ of mandamus, it is an emergency, so she kind of has to take care of it quite fast. And hopefully she has integrity enough to come to the correct conclusion. I mean, the Georgia Supreme Court more or less wrote it out. This is what you need to do. Because if you don't, they will appeal, we get it, and then we will do it. More or less. That is what I read into it. So that is that with the writ of mandamus. But as you can see, Judge Glanville has no interest whatsoever in not handling this case. Careful, are we waiting for this judge's conclusion first? Well, it all goes on simultaneously at the moment. And so Judge Glanville will keep doing this, what he does. He will probably redact heavily from that transcript. But the defense has an edge because they have Miss Bumpus, who was there, who can more or less tell them, this is what he cut out. And as an overwhelming majority of every lawyer, not only on the law tubes, but anywhere, says he shouldn't be near it. This should be handled by another judge in its entirety. And when the judge Glanville claims, oh, it has privilege attached to it. No, it does not. Because attorney-client privilege does not apply if multiple people are listening in. I mean, it's basic law. It's year one in law school, month one in law school, almost day one in law school. It's instances. The only thing I've seen this many lawyers agree on is don't talk to the police. Yep. Yeah, I don't know her history. I don't. The Moshe says, yeah, she usually just agrees with whatever Glanville wants is her history. Okay. But then, if she does, it goes up to the Georgia Supreme Court. They will appeal immediately. But the risk there is then Woody's testimony might be over, and he's done OIF motion towards the door, and yeah. So whatever happens, it needs to happen before he leaves. Before he leaves the stand. But there are 6 defendants and their lawyers. They can keep that cross-examination going for a long while. Is Trinton says she basically got fired from juvenile court. It's amazing she's still on the bench at all. Okay, that's not encouraging. That's not encouraging at all. Okay, while we wait, because okay, so now we have an hour to talk about other things. Yes, this channel do not give legal, medical, or tractor advice. All comments made by the host, guests, or chat are strictly for entertainment and educational purposes only. Thank you, DG. Heather Moshe agrees. Yeah, she bad news. Well, if you then you can always hope. There's always hope. But if she is a Glanville lackey, then it's being brought up to the Georgia Supreme Court. Get back with me. Did you hear about the murder of Tay? Yes, we heard about it. Let's see. If we can find more information. You might know I made a video yesterday about it, in which I concluded this is the information I got out of the news reports, some people chatting on the Twitters, and a few forums. So I had to differentiate all the BS out of it, and then I made a 7-minute video on it. And it seems like, well, Ty is affiliated with Woody. Has been friends for a number of years, apparently. And Tay was mentioned in one of the interview videos, and now he's gone. According to the police, shots were fired from the street level into that specific apartment, which may or may not, well, he was alone in the apartment, Tay, and this apartment, I have now conflicting information. It both says it is Tay's apartment, it is Woody's apartment, and Tay lived, but it is Woody's apartment. I mean, so take everything there with a grain of salt. Main thing is Tay murdered, and somehow it has to do with Woody. Rumors is that during the weekend, Woody was brought in for questioning because affiliation. But I have seen nothing that he is placed under arrest or anything. I see nothing of the sort. Let's see if... Yeah, I mean, there's surprisingly little information out there. Surprisingly. It's been reported on Atlanta News First. It has been reported in basically no newspapers, but on a few videos, among those mine. And I have to say thank you to the people who watched it. So far, 10,000 people have watched that video. That's amazing numbers for me. But also, I had so little information to give, but sometimes even the smallest amount of information is better than no information at all. Amelia Dixon, what about the shooting at Woody's apartment recently? Is that going to be mentioned in court today? I was expecting that the prosecution will bring it up this morning, or will bring it up during the day, because undoubtedly, in my opinion, they somehow will blame it on the defendants, the prosecution. But I mean, this is now a day and a half ago, and I really... I mean, Hot New Hip Hop wrote about it. There are some TikToks, but surprisingly, none of the bigger news channels have brought this up, and I'm not entirely sure why. So I actually don't have any updates on it. And that is a bit unnerving, because this should be huge news. A person associated with Woody is murdered in his apartment after Woody, in a recording, mentioned Ty's name. I mean, newspapers should jump on this, call the cops, see what's going on, give us. Yeah, M Channel, I agree. There's no way YSL would put that out, because they have so much to lose by anybody associated with anybody of the witnesses all of a sudden getting murdered. And Woody is a career criminal. He has done nothing but crimes in his teenage years, more or less, as far as I have found out. So there's a lot of people in Atlanta who now knows that Woody talks to the cops and gives names. And maybe Ty was collateral damage. We don't know, because cops have put a lid on it. Yeah, Woody isn't hurting, as it's Shrinter says, Woody isn't hurting YSL either. They have no reason to be mad at him. So I wish I had updates on it. I really do. But I don't. So, and it's infuriating. I'm good at finding information. I'm really good at it. And it's really unnerving to not find information that should be out there somewhere. Now, there are a lot of rumors, but I mean, even yesterday's video was a bit speculative for me, and I don't want to be one of these channels that just, oh, I heard this and I heard that, and then everything turns out to be wrong. I like my credibility quite a bit, actually. I mean, without my credibility, I have no audience. So I'm just getting infuriated in that I don't find information credible enough to bring to you. So what can we do under this break? Well, it's day 100. Woo! That's nothing to celebrate, but but we do have a little bit left to go through that I haven't gone through yet in this file. We were at day 96, I believe. So we have a bit of that to go through. So let's go through that. Things that happened during these 2 weeks. See here, dun dun dun, dun dun dun. So let's go through that while we wait. Okay, so let's listen.
Folks, we're going to take a comfort break. Let's take 5 minutes. Come back. I'll make a ruling at that point in time on 7. Okay.
And Your Honor, before the state did want to respond to what Mr. Harvey said, and so I didn't know if we could get an opportunity to do that prior to the court's ruling.
Okay. Are we in recess?
So yeah, court is in a 1-hour recess. We are watching video hearings while we wait for the court, because we all know that Judge Glanville's 1 hour recesses, because his 1 hour recess now is him going through the transcript of the ex parte and then apparently hand it out. Now, we do know that he shouldn't be near, as I said earlier, he shouldn't be near that transcript. Another judge should be handling everything about that ex parte meeting. But Judge Glanville is Judge Glanville, and he don't care. So let's listen to some of the hearings.
You said you had a response to Mr. Harvey's comment.
Yes, Your Honor, very briefly. In looking at Gates, Your Honor, specifically the portion in which they talk about the effect on the listener, yes, this was a murder case, but what it says, and this is in Division
2.
2.
I have it up.
Yes. And when you read the fullness of it, it says, for a statement of constitutional hearsay, it must be offered in evidence to prove the truth of the matter asserted. And it cites the statute. Here, the declaring statement at issue was, you're ever lonely, you can call me. The text message sent along with the naked pictures was not offered to prove that Gates' girlfriend could in fact call or had permission to call Wilson if she were lonely. Rather, the text messages were offered to show its effect on Gates and in this case, his motive for committing the murder. An utterance may be admitted to show the effect on its hearer. See also Miller v. State, 275 Georgia 32. For such a purpose, the statement would not be hearsay, as it was not offered for the truth of the matter asserted, but for the effect or lack thereof on the hearer. As such, Gates claims that this evidence was inadmissible because it was hearsay without merit. Here, again, Your Honor, learning about the fact that Kell shot at the gambling house, what Copeland took with that information is he confronted Kell about it. They had a discussion about not just the gambling house, but all their other issues that they had with each other. And then furthermore, during this interaction, which was, I believe, the next day after the gambling house or some time later, Mr. Williams then speaks to Kell about that shooting that happened at the gambling house, and specifically about paying for the window. So again, Your Honor, it's not about what, and I believe it's Gucci Red. I think Mr. Shar said that it was Trivia who said it, but I believe he said Gucci Red told us it was Kell. That information is what he used to confront Kell about about what happened at the gambling house. So that's what the statement.
Crap, muted. What the prosecution does here is she's trying to go around the hearsay rule and the right of confrontation rule by using the effect on listener exception, which is a stupid exception, but here we are. But that shouldn't be used the way she wants to use it. Effect on listener is when something immediately happens in direct when the event actually happens, not when they find out a few days later or even hours later. It has to be at that immediate section. And here they are using a jail. They want to use video where Woody talks to somebody, finds out something, and then after that he tells the cops. After that he tells the cops something. But that's not how it's done. And the case they are trying to use, which we heard, which we will hear from, I believe, does not apply to this case. But we all know that Judge Glanville really doesn't care if it's He only cares about statutes and stuff when it comes to the defense, and then only how he can get around it.
Want to add.
What's your response to the defense's assertion as well as cumulative? Because it's been testified to.
Because, Your Honor, defense counsel assertion is that Mr. Copeland lies about everything. And so what his
No, they don't. Well, that's the defense against Mr. Copeland, is that he lies about everything. That doesn't mean that you can bring in anything stacked on top of each other as cumulative. Because if it's already testified to, and they already heard bits and pieces from cops and stuff, then this is cumulative. But yeah.
iteration of this incident shows is that not just in the February interview, not just in the January interview, January 11th, he talks about it, I think briefly in January 28th and February 20th, that he's reiterating these events to different investigators to talk about the history of what has occurred between them. And if he's such a liar as they want to purport him to be, then he would not be able to recount this historical perspective to the detectives that he is meeting with. So while he is repeating the story, he's repeating it to different detectives at different times to show that he is at least consistent with the historical events that lead up to Donovan Thomas's murder.
All right. Okay.
Yeah, and for you who don't know,
all right, counsels, I've had an opportunity to consider your.
For you who don't know, we are still in the state's case in chief. We are 8 months into this trial, a trial that should have taken 6 months tops. That was what Judge Glanville said pre-trial, 6 months. And we are 8 months in, and the prosecution has more than 100 witnesses left. They are at witness number 80 something. And I have to show you that. Somebody made a breakdown. Well, it's not somebody, Thuggy Daily on Twitter made a breakdown. Here is the breakdown. Let's see here. Breakdown of Judge Glanville's court schedule over the past 7 months, starting November 27th, 2023. 63 full days, 34 half days, 3 days cancelled after Judge took the bench, and 59 days off. Now that sounds like a lot. I mean, that's 99 days. Now you have to remove, I believe we are up to 14 of these full days are hearing days where the jury wasn't allowed in. And half days, 34, yeah, that's 17 full days. So we should be at 80 minus 14. That's 66 days of actual court, of actual trial in front of the jury in 8 months. And the judge blames the defense for dragging this out. No, Judge Glanville, it's you who are allowing the prosecution to call. They would call a broomstick onto the stand to get a video in. They would call a square foot of grass, of lawn, if they could, to drag this on.
area of 603:25 to 6. Oh, hold on.
Sorry.
Get back. Hold on.
Yeah, this is Judge explaining to the defense. Yeah, I read this, and so I will allow it.
(603:25 through 606:05). All right. I'll give you a continuing objection. Defense counsel's is.
Where did I get the info that the shooting was in Woody's apartment? I checked 2 news sources. I checked the live feed from Atlanta News First. I checked 2 different Twitter threads on it, and then I went into 2 different forums, which I frequently read in because there's a handful of people that when they share information, it seems after the fact, okay, that these people were correct about it. So I did that for a few hours yesterday before I made the video, and everything boiled down to those 7 minutes where at the time it was said that Tay was in Woody's apartment when somebody fired into it, and Ty died. A few hours later, there came conflicting information. Now there are 3 different stories. First, it was Woody's apartment. Then it's Ty's apartment. And the third option is Ty lived there, but it is Woody's apartment, or an apartment Woody have control over. That is what I have. So most of the information so far is on the speculative side, because the cops, they put a lid on it. So I can't give you an update on what it actually is, but at the time I made that video, that was the information I had. And as for now, the cops are having a complete lid on it. Rumor is that Woody was brought in for questioning yesterday, but no news reports about it. So it's mostly speculation. The only thing we know is that Ty is dead and he was murdered. That is the sole fact that is still the baseline. Then the further out you go, the more speculative it goes. Had I learned more about it wasn't Woody's apartment, it was Ty's apartment. It was one of Woody's apartments, but Ty lived in it. Had I known that, I would never have made a video, because then it would have been too much speculation for my part. Is sound gone again?
Respect to that. Let's move on to 8. I believe 8 is 6/19/20 through 6/20/20.
That's a rumor.
And
Yes, I've heard that rumor too. I do not believe it has any bearings that it was Woody who ended Ty. I do not believe that. I also don't believe YSL has anything to do with it, because nobody has anything to gain from Ty being murdered, of Woody and the YSL.
believe that is Casey being reluctant to cooperate in the shooting investigation where he's a victim. He says he's concerned they will put the discovery on IGS, or Instagram.
Yes.
Okay. Can you give me the page references, Mal?
Yes, Your Honor. So page 173, line 7.
Today's court has a 1-hour recess because Judge went into his chambers because he's doing the final redactions before he releases the transcript. That is the information we got for 2 minutes when court assembled this morning. So that is all we know. at this time. But we do know that he plans to let go of the transcript, a redacted version of it, which isn't good enough. What would be good enough was Judge Glanville excusing himself from everything regarding that ex parte meeting, and that someone else handle it, not him. He's a witness. He can't be witness to the ex parte meeting, judging over the ex parte rulings, and make the decisions on what information that should be handed over to the defense, because he's a witness.
Okay, all right, Mr. Sharp.
So, Your Honor, here is another example of Mr. Copeland stressing the social ramifications of cooperating in this investigation. Again, when I say this investigation, I'm referring to an investigation against people that shot at him allegedly outside of his house while holding his child. So we get into this, it's almost bolstering, it is bolstering, where he's showing a fear of testifying, but again, it has nothing to do with these gentlemen. It has nothing to do with the investigation of these gentlemen seated in court today, but it has to do with an entirely different group of individuals from.
I need to get something to drink and change, because I've been working all day. I'm still, I need to change into something more comfortable. I'll be right back after I get myself a cup of coffee and a change of shirt. Okay, but you keep listening to this pile of this information
That are allegedly associated with an entirely different group. So it has no relevance to this case. It creates the impression that Mr. Copeland is universally opposed to cooperating, universally fearful, universally has been threatened and feels threatened. But the reality is he's expressing fear, reluctance, and all the rest regarding an investigation of an entirely different group of individuals. And it's likely to confuse the issues. It's unfair prejudice towards our clients, where there's absolutely no evidence that he's been fearful, that he's been threatened by any of these gentlemen or anyone associated with these gentlemen. So we would argue that it should be excluded under 403. 401 and 403.
All right, madam, can you play it, please?
And Your Honor, I'll start at 6/19/40.
You know my name? In that car that's gonna put them there. Like you worried about the wrong thing. I'm worried about when you get locked up and you get a shirt, they get to see I circle each picture and put my name on them. You're gonna send it out to the screen and be like, I done told on him. And they're gonna put it out on Instagram and Twitter and they're gonna tell everybody. And then guess what? They're gonna start like, then I'm gonna be just like what then? Nobody won't be around. So you worried about your reputation as opposed to your life and being a free man? It's up to you. I don't want to go back and forth. You gonna do it with you or you not?
And Your Honor, that's the conclusion at 6/19/44. And Miss we started at 6/19/06. And Your Honor, may I respond?
Yes, ma'am. What's the state's response to Mr. Chardon and the defense attorney saying that violates 401 and 403?
So again, Your Honor, one, this is a impeachment by contradiction. Again, in court, Mr. Copeland has said repeatedly that they forced him to pick out Tay, and that he was not afraid of snitching or telling the police who did it, but that Tay did not do it. So one, this is a contradiction to both of those assertions that he made in court. Here, again, for the totality of the case, Mr. Copeland, back in 2015, and we believe even now, does not want to come to court to testify against whether it was Tay or these individuals. So this shows, one, he contradicted his testimony as to what he did back in 2015 as it relates to Tay. And then two, it shows not that he's fearful that any.
Yeah, there it is. They are talking about the video where he mentions Tay. Now she mentions Tay, and a few days after this hearing, Tay is gone. Coincidence? Don't know. But it's a hell of a coincidence.
Anyone's going to harm him, because the state has never asserted that any of the defendants were going to harm him. What the state has asserted is that he does not want to come and testify against them. And this is a prime example of that. So for those two reasons, we believe that this portion should come in. Additionally, Your Honor, when Mr. Shar says this had nothing to do with this case, that is not true. What Mr. Copeland is talking about in this interview is a retaliatory shooting that occurred as a result of Donovan Thomas being murdered. So again, putting this all in context, Mr. Thomas was shot and killed on January 10th. Over the course of about 6 to 8 weeks, there are multiple shootings. We went over that yesterday, Your Honor. And one of the final shootings was on February 19th, when these group of individuals that were associated with If Gang shot at him, his child, and his baby. And they're trying to get him to identify who one of those individuals were. So it does have something to do with this case. It has something to do with the overall retaliatory shootings that occurred as a result of Mr. Thomas being murdered. And again, in this section, he talks specific about having to come to court. Like, that was his concern here. Like, I have to come to court and I'm going to have to testify about this. He was concerned about doing that. And Your Honor, we believe that that is also why he's changing his testimony in court today. Court during this trial.
Amelia Dixon, didn't Woody say that Gator is hard to convince her of whatever story he was telling her? Yeah, but in all honesty, Officer Gator is a moron who should never be accepted into the police academy or any academy. If you remember from when she testified, she is a college dropout, worked random jobs, then applied to cop school and became a cop. And for the first 3 or 4 years, she refused to answer 911 calls. And then she went department jumping because nobody wanted her, because she's that worthless of an investigator, until she got to the gang unit, which apparently in Atlanta is the unit where the absolute worst cops, the incompetent cops, end up. And still, they are experts in this tribe. And after she worked for 19 years, not even 20 years, but she quit. And after a month or two, she started working at Cobb County DA's office as an investigator for 3 months before she left. And her answer to the question why she left is because she said, well, I realized it wasn't for me. Now, I do labor law. Whenever I hear that, I know that she was given the option, either you quit or you're fired, you incompetent hack. And so she quit. That is my opinion about that. So anything that detective, officer, lieutenant, whatever's Gautier touched in her career is completely worthless as evidence. That's my opinion.
Any further argument, Mr. Weinstein?
No, Your Honor.
Mr. Matthews?
No, Your Honor.
Mr. Williams? Mr. Harvey? Mr. Steele?
Nothing.
Okay, all right. All right, in considering the both sides' arguments in regards to defense 401 being relevance, 403 being unduly prejudicial, or and the state's assertion that is impeachment by contradiction, the court does find it is relevant for the,
Of course
and
it does.
that even using 403 as a balancing test, it is more probative than prejudicial and shows impeachment by contradiction. So I'm going to allow it over defense
Nobody's
objection,
surprised.
and I'll give you a continuing objection in regards to that. All defense counsel. All right, let's cover.
Gina, as everybody has already known about Woody's interrogation tape, so there's not much that is a new reveal now. So don't think Faye's murder is related to this case. It doesn't have to be, because the prosecution is that sneaky, that malicious. They will try to use it. I can almost guarantee they will try to use it in this trial. I would be surprised if they don't try to use it in this trial.
Number 9.
My
Number
coffee-
9
coffee is done.
is
Be right back.
62630 through 62705. And as you framed it, Gaither gives speech about the need to put an end to the shootings. All right, sir, go ahead.
I was gonna,
You want to play it?
yeah, can we just play it and then,
Yes. And Your Honor, it's page 181, lines 8 through 12. I'm gonna start a little earlier at 6:26:22.
I can't deal with this shit, man. And I understand that, but you gotta help you right now. We trying to get a stop to all this back and forth shooting. You trying to back and forth shooting? Gee, they only shoot.
No, this isn't from today. The court is in recess because George Glanville is in his chambers doing the final whatevers with the transcript from the ex parte meeting. And he said it will take him an hour, and that was 40 minutes ago. So I guess it's another hour because this judge can't tell time.
Well, shooting at you. Shit. We trying to get a stop to this. And we pulling every resource in the city that we can, but we can't be everywhere. So if I gotta pick these motherfuckers off one by one, waiting on evidence to come back, yeah, I'm gonna do what I gotta do, but you gotta fucking, I'm doing what I gotta do, man. Help me out. I'm doing it. Hell, man. Why did I go through this, man? I don't know. I don't know, but I'm gonna do it. Bruh, I'm ready to get started on the aftermath.
And every month I get to gift 10 memberships, 10 free memberships. And I did that right now. And it was gifted to Tammy Bogard, Heather Mosher, M. Shannon, Gina S., and Susan Davidson. Welcome to the Viking crew. You now have access to all my members-only content. And I can gift 5 today and another 5 tomorrow or the next stream. So you got it. And for you who think, oh, I want to do that too, become a member, become a part of the Viking crew. It's $3 a month, and you get access to all members-only content. And that my members-only is not much about law. It's about me, the farm, the renovations, and stuff like that. And oh, thank you, Vintage CB. Gifted 5 memberships. Thank you so much to Lady Star, Patty G, Matt, Spiritual War Exposed, and Patty B. So both Patties in my chat got a membership. Yay! Thank you so much, Vintage B. Thank you so much. Thank you. Thank you so much. And Capnot Williams gifted 5 memberships. Wow, here we go. It went to Catherine, Kathy Trout, Fat Grandma, Dave Umbarger, and Fiery Red Podcast. Now you also have access to my members-only content. Yay! Thank you. All of you. Thank you. Thank you. Thank you. Thank you. Thank you. All right, let's now get back to listening to this for a bit until Josh Glanville is back from his 1 hour. Let's see, how long has it been now? It's been about 50 minutes since he went to his 1 hour break. So I assume it's at least a half an hour away.
I'm ready to get started on that. I can't work Thorpe's homicide. I'm picking up the pieces of the aftermath for the homicide.
Woodies. Probably not related to this case at all.
Here.
Your Honor, we stopped at 6:27.
Oh, by the way, if you want to be gifted a membership, you have to put it's a small mark. If you go to the top of the chat, you see the gift baskets. If you press one of these, you should get the option to receive memberships if somebody gifts again, if you haven't done it already.
So, Your Honor,
All right, sir.
my objection, again, these statements are allegedly prior statements. I mean, the reason we're playing for the jury over our objection, the defense objection, is because they're prior statements by Mr. Copeland. We have the non-declarant, Investigator Gaither, just talking about the need to end the shootings and how she's going to end the shootings, and the city's putting every resource into ending the shootings. And it really, we're all citizens here. We're all city of Atlanta. We're all Atlantans. It's not the city versus these gentlemen. It's not supposed to be the police force in the city versus these gentlemen. And it's supposed to be a neutral. And that's the impression that the jury is given when they're exposed to, again, this speech. I call it a speech, but whatever you want to call it, by Investigator Gaither, where she presents this as, look, it's, the city and all the authorities and the police department, we're all working to try to put an end to these shootings. And it's you guys and Mr. Copeland, it's your information that will put an end to it. And it's your group that's involved in all this. I believe it's inappropriate. I believe that invites the jurors to consider it invites them to take into consideration factors that should not be considered in that jury room. And it's essentially an improper argument. If it was made during closing, we'd argue that it's an improper argument. It's, you know, just because it's not a closing argument doesn't make it not improper. It's improper for the jurors to hear that type of talk by Investigator Gaither, especially considering the whole reason that this tape is being played over our objection is not for Investigator Gaither's words, but for Mr. Copeland's.
All right. Ms. Hilton.
And again, you have to look at this in totality, Your Honor.
No, you don't. You do not have to take this into totality. You need to view the section you want in should be viewed by itself. It is the jury's job, once they get all the evidence in front of them, then look at both the totality and the individual evidence. But you can't ask of the judge, well, in the totality, this is relevant. No, you have to show this is relevant because this specific reasons and this specific case law, in my opinion.
This starts off with Mr. Copeland saying, why do I have to go through this, man? And Gaither is then going into, I need you to do this. I need you to identify who it is so that I can get started on my investigation. So I can continue my investigation. I can continue my work. So
that is Detective Gautier or investigator or whatever. That is her soliciting a specific answer that he probably already knows Woody doesn't have. I would be shocked if that, because we see them walk in and out of that damn interviewing room where there's no recording. Just saying.
While Mr. Sharp calls it a speech, she's responding to Mr. Copeland saying, why do I have to go through this? And if you look at his body,
you need 20 years to get full retirement. I'm not entirely sure about what the Atlanta Police Department has their cutoff, but you can get a partial, I believe, at 15 or something, but 20 is the big cutoff in most counties and police precincts, 20 years on the force. But she left after 19 years. Just cause. No, it's not writ of man's anus, it's writ of mandamus.
language, he was struggling to move forward and just make the identification. And so she's trying to encourage him to go ahead and make.
Maybe he was struggling because he didn't know. Shocker! Home Alone face. Oof.
The identification so that she can move forward with her investigation, Your Honor. So again, as the state said earlier, that's in contradiction to what he said here in court. What he said in court, they were forcing him. No, they were talking to him about it. He's responding back to her. I believe in court he may have said they made him say Tay. That's not true. That's what this shows as well. And so given his in-court testimony, this is contradicting what he said here in court.
All right. Any further argument, Mr. Weinstein?
No.
All right, Mr. Matthews.
Nothing to add.
Ms. T. Williams. Mr. Harvey. Mr. Steele.
Your Honor, I don't see why this adds anything. I join everyone else, Mr. Sharp's argument. The detective said we're going to pick them off one by one. Every officer is going to be working. The state is saying that Detective Gaither is encouraging Mr. Copeland. That's not needed. That's not the purpose. We don't just play recordings of me speaking with a witness to say I was encouraging the witness. This is just an out-of-court statement. offered to bolster the detective, and that's really not appropriate in my opinion, and it's irrelevant under.
She's already testified in court. She testified that all her reports are gone and missing. She couldn't get a hold of it. And the prosecution says her reports are missing. So that is why we only have the videos who magically didn't go missing with all the other work that investigator Gautier did. Isn't that strange? What a coincidence. Every time they put a cop up there that has retired from the force, their reports go missing. Wow.
There 4012 and then 3 would be a waste of time. A lot of this, these are, the state wants to play, these are, I believe, 18 hours of recordings. I mean, at some point, they don't get to just play all these recordings, so I would object.
And I can respond to Mr. Steele specifically, if the court may.
Yeah, I'm in, trying to kind of see why the detective gave it before it starts. We're trying to stop this. We're pulling every resource in the city. We can't be everywhere. So if I gotta pick these motherfuckers off one by one, waiting on evidence to come back, then I'm gonna do what I gotta do. But you gotta I'm doing what I gotta do. I'm doing it. I'd be inclined to take that out, but the other stuff would be admissible under impeachment by contradiction or relevant.
So which line, Your Honor?
Line 8 on page 181, line 8 through line 12.
Not even Judge Lamb.
That's fine, Your Honor.
It does. I agree, Mr. Steele. It doesn't really add anything to it, and it's for the reasons he mentioned. Okay.
Okay, so line 8 to 12. We can
Yes. Anybody else have any other comment or any other argument in regards to number 9, 62630 or thereabouts is 62730?
And now the 1 hour recess is 1 over 1 hour. But we already know that if you have been watching this trial, as I have done from the start, I've been covering this damn case for over a year. Judge Glanville's hour is at least 90 minutes, but we can still check this part of the hearings out until he gets back.
All right. I'm gonna, other than that particular admission, omission, or exclusion from, that'd be page 181, using state's transcript, lines 8 through 12.
Oh, Vintage CB, I might have missed this previously. Any word of the missing video with the car jumped to that? Oh, that is almost 2 months ago. The missing surveillance video on the cross-examination, they, on the radio chatter, or whatever you said, call it, between cops. In there, you can hear the cops talking about watching the surveillance video. The prosecution has always said there is no surveillance video. There were no surveillance. Nobody remembers the surveillance camera. But then the defense showed, look at the crime scene photos. And then they did the pinch and zoom. What's that? It's a surveillance camera. And then you hear the radio chatter from the cops. When this Toyota shows up, let him through because that's the owner, so we can get to the surveillance video. And then a few minutes later, yeah, me and the cops are watching the surveillance video. It's in there. The prosecution claimed it was never there. And the defense showed that the prosecution lied. Did anything happen with that? Proving that the prosecution lies? No. because Judge Glanville is a part of the prosecution team and he wants this trial go to the end, get a conviction, so he can lean back, pick his ears, I don't know, being a 2-hour word about it. It's infuriating.
The rest is, can be played.
Thank you.
Okay.
Yes.
All right. And I'll again, admit it over objection and give a continuing objection. Does the defendant still maintain that none of this is proper and they should not be played? So, okay. All right. Number 10. And number 10 is 6:30:30 through 6:31:50. And you are saying that that's 404A evidence about Mr. Stillwell
Yeah,
and inappropriate comments about character.
yeah, 404A and B.
404A and B. Okay. All right, sir. Oh,
I'm sorry, Ms. Hill.
you want me to? You want to play it first?
Yes.
Oh yeah,
Okay,
it
all right,
should
let's
have
play
been a mistrial months ago. But Judge Glanville refuses, and then he refuses to give a certificate so they can appeal it during the trial. He wants to save everything from after the trial because money. And why do I say money? Well, because an appeal costs a ton of money. I will give you an example. The Zachariah Anderson case was 21 days. They had to pay almost $20,000 to get the transcripts alone from 21 days. We are at day 100. We are not even close to ending the state's case in chief. To get the transcripts alone from this trial is, it's close. If it's not over $1 million, it's close to $1 million for the transcripts alone. The only person among those defendants that can afford that is Jeffrey Williams. And that is why this judge refuses to allow appeals to the appellate court or the Georgia Supreme Court voluntarily, because he wants to make it as hard and expensive as possible to get this appealed.
What transcript page is now?
The other portion will be page 185, line 17, through page 186, line 19. And we'll start 6:30.
I'm
6:30 what?
I can't wasn't taking it serious like how it is. I really thought they wasn't. I didn't think they would do it. I didn't think these niggas would try to shoot me. I'm pretty sure I thought we really would try to do a kill. They showed me wrong. Well, I know it him for shit. He been on Twitter going back and forth with Shannon. Yeah. What the hell? I'm telling Shannon, why the hell you ugly? You can go on Twitter. What's Shannon been up to? Because I know he ain't just gonna sit and let it ride like you getting shot at and all that. I know that. And you know what I told Shannon? Man, that boy deal with him. I'm man, he'll pay him. You know what Shannon told me that night? The night they shot me in bed. You know that night? I was crying. And you know that night? Man, bro, hell nah, bro. We just can't keep paying. I'm like, bro, fuck this shit, bro. Let them have it, bro. Let them have it, bro. They kill me, bro. You know what's going on, bro. Just start with Lieutenant police involved with it. Just start with it, bro. We ain't going to jail, so we ain't do, bro. I'm not going to tell you that. But one of these folks think we did this shit. And they said what I told him. He like, she looked at it. She like, bro, I'm telling you, bro. If they kill you or they hurt you or they, bro, they got to kill them too. Just like him, bro. They don't get your shell out of it, bro. We already in the bad day. We with people we never thought we'd be with, bro. Bro, fuck that shit, bro. Never have. That's why I really ain't getting in there. If I didn't, like, I feel
And stop at 6:31. So sorry, stop at 6:31:51.
All right, Mr. Sharp.
So this testimony or this out-of-court statement by Mr. Copeland about my client has absolutely no relation to any charged conduct in this case. It's propensity evidence. There's no evidence of something that happened that I know of. There's no evidence of something that happened after this date that was supposedly done on behalf of Mr. Copeland in as payback for either the January 28th shooting of Mr. Copeland in the car or shooting at Mr. Copeland in the car, or the February, I guess it would be 19th shooting of Mr. Copeland or shooting at Mr. Copeland outside of his house, other than, of course, Mr. Copeland shooting back at those individuals and hitting them in their car. My point being, Mr. Copeland is essentially saying that Shannon has encouraged him to and said, we need to get payback for them shooting at you. And Mr. Copeland saying, no, I said, let it be, let it be, let it be. This is not testimony about any act that's charged. This is mere propensity evidence that Mr. Stillwell is someone that when something's done to him or one of his friends, he's going to seek retribution from the other side. And again, if the state had overact, and I'm making this up, that happened on March 3rd of 2015, where they allegedly saw the car that was shooting at them on January 28th, then I would say, okay, maybe that has some relevance to this specific act. But there's no act that's charged. And what the state wants, essentially the logical conclusion based on hearing that is Mr. Stillwell is, a hothead that seeks revenge. That's propensity evidence. That's exactly what's not supposed to come in under 404B. And so I would object. It's improper character evidence. It's improper propensity evidence.
All right, sir.
Okay. Are there movements in? No, not yet. I'm looking at the court stream for today because everybody wants to know what will happen with that transcript and how accurate it will be after Judge Glanville has made his shredding, I would assume. Of I mean, at this point in this trial, with everything that has been going on with the prosecution, the corrupt cops testifying, and this judge who don't know basic law, apparently, even the wildest speculation I had in the beginning of the trial, these people have exceeded my expectation on how corrupt a trial can be. So, did he order a paper shredder to his office? I don't know. Maybe he always had one. I don't know.
Okay. I'm going to use Mr. Adams' favorite saying, easiest decision I'll make today. All right. Anybody else have any other comment about subpart 10, 630, 30 through 631, 50? It's going to be omitted. Anyone? All right. Okay, we've gotten through the flaggings of Mr. Sharp. Does anybody else have any other time periods they wish for me to discuss with the court? All right, thank you, Mr. Steele. Mr. Harvey?
If you have any questions, don't be scared to ask it, but just in case, put that big red question mark so I can spot it in the chat. That way, because it's not necessary to super chat to get a message through. I try to read all your chats, but sometimes I miss it. Chris says here, I'm surprised they haven't offered plea deals to these 6 men. Oh, they have. They have. These are the 6, and then there's about 10 or 12 more who refuses to take plea deals out of the original 28 defendants. So, and these 6 are being tried together. The other 10 or 12 have been severed from this case, and their trials will begin after this one. And these other 10 to 12 people are still in jail, awaiting trial. After, what is it, 18 months? No, it's 2 years. 2 years in jail, awaiting trial.
Ms. D. Williams? Mr. Matthews?
No, Your Honor.
Mr. Weinstein?
No, Your Honor.
Okay.
When I say no, it's with reference to my continued objection for severance and instructions with regard to all of this evidence. I don't want that to be deemed to be a waiver on the record.
Okay, Mr. Harvey, in no way, I'll note it again for you that you have moved for severance and for 105 instruction, which the court is going to give you continuing objection on.
Yeah, Mr. Harvey represents Mr. Nichols. Mr. Nichols, in this entire indictment, all the charges is mentioned once. But Judge Glanville refuses to give Mr. Nichols his own trial.
But I'm going to deny that at this time again, okay? All right, sir. Okay. All right, councils, let's talk a little bit about way ahead in scheduling. I believe that you all have, as well as it pertains to Mr. Copeland, June the 10th interview, which is the longest one. It's 9 hours. Is that correct? All right. Have you all been working on?
The combined interviews they want to play is 18 hours. One is 9 hours long, in which the prosecution might want to redact half hour from. And that's not all. After the videos, the interview videos, there are jailhouse calls of at least 3 hours. It's so stupid.
Or I'm going to ask the state first and then defense counsels in terms of what you've identified as to what you're going to play and what you wish to omit.
Your Honor, we sent to defense counsel, I believe on Monday, the areas in which the state, intends to redact. Yesterday evening, Mr. Shard, I think, sent me a portion of the areas that they would like redacted. We haven't had the opportunity to look at those. And then I believe Mr. Adams was supposed to send me the secondary portion of that. And so we'll be looking through that over the course of today and this weekend to determine what, if any, areas we can agree to. Once we finish talking about June, Your Honor, I would briefly just want to get some clarity on February 21st, but after we finish the June discussion.
What do you mean you want clarity on that?
So we submitted
21st.
We submitted some redactions for February 21st. And I don't know if kind of along the same lines of the conversation yesterday. If there are areas that the defendants wanted in that the state intended to redact. And if there are those same line of area, we understand the court's ruling from yesterday, but we just wanted clarity because we don't know. And it could be an offline conversation I can have with Mr. Shard to see
I think
what their position is.
I think I can answer this. After speaking with other attorneys involved in the defense of other individuals, I believe that there is an objection to the redactions of the timestamps identified by the state.
Yeah, this is the defense now objecting to things the state don't want to play, which is interesting. You would assume that the state is interested in playing its entirety, but it seems like they want to take away the few inklings that shows that Mr. Copeland wasn't truthful in the police interviews by naming names and events he cannot have seen or heard or know about and stuff like that. But the prosecution, no, that's unnecessary. We don't want to play that because that will be bad for our case or something.
We understand that the state, in their presentation of the case, they may choose not to present some of these excerpts when they play the tape.
Which tape were we referring to?
February 21st, 2015.
All right.
But I believe that the defense is going to seek to admit portions that the state is not going to seek to admit.
And certainly that, I mean, we can have a similar discussion that we had yesterday, or I can authorize, unless there's been a specific objection, I'm going to say you can play it during cross-examination. Like similar to what I did yesterday.
Yes.
And that's fine, Your Honor. We'll
Okay,
object
yeah.
at the appropriate time.
Yeah, if appropriate, yeah, I'll rule upon it, but most of the things that, unless there's clear argument to the contrary, will be fair game on cross, okay?
Thank you, Your Honor.
Okay, so let's talk about the June 10th interview. So is it possible for you all to, like, consistent with, this has been very helpful for you all to identify the time periods and for us to work down through them and have discussion one way or another? Are you all in a position to potentially put something together by Monday, and so we can kind of go through the June 10th interview?
The good news is we're all operating off the same transcript for June 10th, and there is a transcript. I believe the transcript's about 550 pages. I made it through 380, and I've identified the specific spots that I object to, and I believe
I will
that
tell Mr. Jingles,
other attorneys involved in this case adopt my arguments for those first 380. Mr. Adams is diligently working. He's identified the rest, and he is going to send that information over to the state at some point. I don't want to speak for him, but I know he's been working on it. So I think that the state has given us their proposed redactions, correct?
Correct, Your Honor, but I think we're going to be in the same position. So we really need their redactions, because I think the state is, we're going to redact what we're going to redact, and if they choose to want to play certain portions, we can object at the appropriate time. So I think we really need to know what their redactions are in order for us to have a meaningful hearing, hopefully on Monday.
So right now they have about 2/3.
Okay.
Just by the transcript length, about 2/3 of the redactions, and then Mr. Adams is going to get them the rest.
Mr. Adams, will you be finished by Monday?
Oh, absolutely. They'll have them. I can give it to them about Saturday.
Okay. All right. Okay.
That works.
All right. So we'll work on, now, as it pertains to, since we'll probably take the most of the day with that, I'm inclined not to call in our juries for Monday.
Which is today.
They
They are talking about
remind
this
the board that
Monday.
we also have the jail phone calls.
Yes, and there's 11 of those at 2.5 hours.
Oh, 2.5 hours. I thought there was more. But that's still a crap ton of jailhouse calls. And seriously, just a jailhouse call. When you call from jail in Atlanta, you are being told that it's being recorded. So why for the love of everything that's holy, do you think that speaking in code will help if you are in Fulton County Jail? Why even bother talking about crimes when seriously, they say it out loud. When you make the jailhouse call, this will be recorded. I don't get it. Somebody please explain to me why people admit to crimes in jailhouse calls. Why? Why? You would think, because I believe Fulton County Jail have had that practice for 30 years. And people still, to this day, talk about crimes on jailhouse calls.
Recall Tuesday the 25th. We'll probably just work from about 9:30 to about probably shortly thereafter lunch. So my inclination as well, I don't think we're going to probably finish with it's possible that even.
Yeah, no, they're just talking about scheduling. Let's see if they have anything more interesting. July 1, 2, and 3. Yeah.
Okay, all right. We're in recess until
Yeah. So let's still nothing from today's court. Judge is still on his recess. It's been over an hour, but nobody is surprised about that. So let's go to day 97. Let's see here.
For our discussion this morning. In the future, councils, if you are sending out like a product like that, it's helpful if you send that to Ms. Weaver or copy Ms. Weaver as well. She uses that to follow along. So just for future reference. All right. Okay. All right.
Susan Davidson says, tell me this, if he's entitling something, why is it taking so long? It shouldn't take any. He should just go in there. That transcript should be done. Should have been done for weeks now. Just to hand over. So why it has taken this long and why he's still taking a recess to go through it? Because he don't want the defense to know exactly how much of a crooked judge he is. But we already know, just by having that ex parte meeting, he did a serious boo-boo.
Okay. State, do you all have the June 10th interview queued up?
And again, similar to what happened on Thursday, last week, the state will only be focused on the redaction that the defense has, as we the portion that we don't intend to play, we will not play. And if the defense wants to play certain portion of that, then at the right time, we'll object at that time.
They can play anything you don't include in the direct of Mr. Copeland, unless it's excluded. I'm gonna let the defendants use that as part of their cross-examination, be fair game, unless it's objected to, and then I exclude it. But if not, it will just be, they'll have that right to do so.
Yes.
Okay, all right. Do you all have a transcript?
Yes.
Okay, can I see it? Please.
And Your Honor, for the purpose of the record, we'll let the court look at State Exhibit 378, Yankee Echo.
Is that the transcript?
Yes, Your Honor, that's a transcript of the June 7th hearing.
The transcript they are talking about now is the transcript to the video, not the transcript of the ex parte hearing. Because somehow the prosecution's transcript does not really, in some shape or form, it not always reflects what's being said in the video. Imagine that.
What are you marking as the interview itself?
It would be 378 Yankee Echo.
Yeah, still found case law that Thug needs to be present for this handover of transcript. I'm hoping they will do it in open court, but I do believe that Judge Glanville will refuse to do that. But who knows? They are not back yet. We are now an hour and 20 minutes in to the 1 hour recess. Nobody's surprised about that either, because it's Judge Glanville. But we are watching these hearings that occurred last week. I believe this is from Wednesday last week.
Okay, well, we can start with the first one. Mr. Sharp, where are you? Okay, all right. Transcript page 42, lines 5 through 42.
No, Your Honor, it's 42 line 5 to 42 line 13.
And Your Honor, the state has no objection to redacting that portion.
Excuse me.
That's correct, Hell-Raising Angel. You can't watch evidence tampering.
Okay. Number 2 is, I think, 10, 13, 53 through 10, 16, 59.
And Your Honor, that's the state's redaction, and we agree on that portion. And so We don't object. The defense wants page 55 through 56 out, and we don't object.
And Your Honor, the only thing in this particular one, I said 55 to 56, but what the state suggested, and I agree with the state's suggestion actually. The only thing I would say is I think that instead of ending at 55 line 9, it perhaps should go to the end. Instead of ending at 59 line 9, I believe it should just go to the end of page 59. Or at least the line 16.
Your Honor, the state intended to play line 9 through
16
Oh yeah,
or through the end of the
come back
page.
Through the
after
end of the
comfort
page,
break
Your Honor,
or an early lunch.
because this speaks
Something
about
about
his conversations with Shannon.
Who's Lully though?
I don't think it says Loli, Your Honor, but I'll play the portion.
Could you-
Ooh. Yeah, I saw something about it's a First Amendment ruling on something. I saw it just where did it go? They really slapped the Fifth Circuit about a ruling of theirs, where if I remember correctly from the text, that the Fifth Circuit completely misunderstands the statutes regarding the First Amendment. And that is interesting.
And that's what I'm concerned about someone getting killed.
All right, let's hear it, please. Good morning, Mr. Votz.
Can we plug this back in? Do something. Yeah, we're gonna play, we're not gonna play up until 10:16.
Okay.
And where in the transcript is this?
We are page 59. We'll be right around line 6.
Okay, great.
Are you saying? Yeah. I seen it. But before this, Lordy ain't no Lordy. When Lordy got killed, like my guy did, me and Shannon was talking, Lordy got killed. I was like, man, Shannon, hey, Shannon, what's up, bro? I think when I first started trying to talk to him, man, he pulled me all the way to the side. We started talking. And he just told me like, what's going on? He just like, this when he told me about the troop situation. He just like, shit, boy. Damn, you still hang with these niggas, bro. This nigga ain't getting that for a nigga, bro. Don't tell him.
So that's the section from 10:16 about 10:17 to the end drive. It just gives context. Before this, it appears that Shannon and Copeland had stopped talking, and he's giving context to when they started talking again.
Okay, but who's Lully?
You're right, I don't know, but I think that's just giving context for Copeland, and he's telling Detective Gaither when that occurred, that's when Shannon and I started talking again. So it gives context to whenever he started talking again. So the more relevant part is he's giving the officers context to when him and Shannon started conversing again.
Can I just make a suggestion? Why don't we just start on, if it's important that the state get into Shannon and Mr. Copeland talking again, why don't we just start on page 59, line 14 with hey Shannon, what's up, bro? That's the first started back trying to talk to him. They can just go from there. We don't have to have mentions of someone named Lily or Lully getting killed, and none of us know what that's even about.
Yeah, that's not an issue. That's fine.
You agree to that? Because I was going to suggest that's probably, because we don't know who Lully is. So, consistent with what Mr. Short recommended, we'll just start at line 14. Hey, Shannon.
This wasn't done pre-trial because the prosecution didn't want to. They have, throughout this trial, they have been adamant in throwing garbage from deep within the discovery and just, now we're going to use this. And the defense says, we need to prepare for this. And then the judge says, how long have you had this? And the prosecution will say, we gave this to them in early 2023. Oh, then you should be prepared. Yeah, but it's 7 terabytes of documents. And they don't know when the prosecution will use what evidence. And it's so infuriating.
Line 14, page, I'm sorry, I didn't put it in. Page 59. Hey, Shannon, what's up, bro? All right, number 3 is a discussion about.
Ooh, directly from Kathy Russon from Law and Crime. Come on. 25 minutes ago, we received an email from the court in YSL Young Thug trial stating that the in-camera hearing that was scheduled for today regarding the ex parte hearing transcript will be in open court, not in chambers. And that was 25 minutes ago. They expect things to get started soon. Well, they haven't started yet. So I just wanted to show you that. So, yeah. This would be interesting. But George isn't back from his
Wayne
1 hour
shooting.
recess yet.
And Mr. Sharp, you indicate that Casey lacks personal knowledge.
And well, the state is in agreement that we're going to redact out Casey's comments about, or Kenneth Copeland's comments about the Lil Wayne bus shooting, correct?
So, Your Honor, 61 through 77, those pages don't just discuss the Lil Wayne bus shooting. It discusses a variety of different subjects. And so I think the best way for me to break down 61 through 77, there's some things we agree that we're not going to play, but there are other portions of this that we do want to play.
And that's fair. I think it starts on 61, page 61, line 12 is the discussion, and they keep going back to it. So they lead that discussion about Lil Wayne, us, and then they keep going back to it throughout this meeting.
So I'll say, Your Honor, from page 61, I believe it actually starts at line 6. From 6 to 21, we agree to redact.
So,
On page 61,
Oh, on page 61.
Lines
line
what?
6. And it's really a portion of line 5, but fully line 6 through line 21.
okay,
And that portion is from 1018, around 101842 to 101909.
all right. Mr. Sharp, you okay with
This
that?
judge is always dragging his feet.
Okay, all right,
The next portion that the state wants in is page 61, line 22 through page 62, line 14.
all right, I'm with you and I'm in agreement.
Okay. The next part that we agree that should be out is page 62, line 15 through line 22.
page 62, what, line what?
15 through 22.
Okay, Mr. Sharp,
So I agree, with what they want to take out, and then on page 63, just so everyone's on the same page, 63 seems like a discussion that Kenneth Copeland is having about information he got about Jeffrey Williams wanting to hurt him or set him up, is that correct?
Yeah, so the next part that we do want in is page 62, line 23 through page 70, line 16.
to page, 3 is what, I'm sorry, ma'am?
Through page 70, line 16. Oh, excuse me, they want out, but we would like in, sorry. Or, I believe they want in.
Mr. Jingles just came in through the door. Well, not well, his door. Trying to get him to get over here.
That's pretty much it.
Still no movement.
And I'm sorry.
Almost.
They want out, page 6.
This 1 hour recess is soon to be 2 hours long. And the judge isn't back.
62, line 23 through page 70, line 16. We will be objecting to that.
Okay, 70s. Let me just.
So the state wants to play from 63, page 63, line 23 to page 70, line 16?
Page 62, line 23 through page 70, line 16.
All right, and the defense doesn't want to have that played.
Your Honor, I can just confer. I think, the defense is gonna object to that, so if you could just play that.
Sure. Okay. Can you,
Yes.
okay, all right. What
It'll be,
video period is it from?
yes, right, it's going to be from 10:19. Probably more around, I'm going to start it at 50, but I think it's more like 10:19:58 to 10:25:22.
All right. Whenever you're ready.
What that got to do with? Why is Thug in the mix? Like he's a don around this motherfucker. Like and that's what first told me. Who told me like it was a girl. You know what I mean, she just I put a big baby for it. It was on the day I put a big baby for it. I had baby Sunday. I put a big baby for it Sunday. Yeah, it was Sunday. I put a big baby for it. Me and my baby and my little partner Kino and me, Kino's baby and DJ, CJ. So we put up. Everybody got color, they was on there with that type. Right, me, then when Kino White, me, CJ White, the baby, me, CJ White. So that's not the way. Yeah, but see, Battery got in the car, she just like, hey bro, I'm gonna tell you something, don't say nothing. You know what I mean? I'm like, what's up? She's like, throw up there, this and that. I'm like, no, what is it? What you mean? She like, but then don't trust that nigga, bro. I mean, that's what he trying to set you up. That's why every time I got in jail, someone got shot up. Like, what the hell? These niggas keep shooting shit up on the night out. So you think it's Thug them shooting at your people? Nah. I know it ain't Thug them because they got these niggas thinking it's me. See, I had seen Monte. I seen him, who is Monte? Yeah. Okay. I seen him the other day, like day before yesterday. I seen him yesterday morning. I went to the graveyard. When I seen him, he was in my cousin's house. When I heard what happened, I was leaving for him and was like, damn, bro, we go up again. Right. So I'm like, damn, bro. Y'all ain't gonna let him man back for a you know? Nope. You say you grew up with him? I didn't know his first name, Wesley. I don't know his last name. No, but when I tell like, damn, bro. Motherfucker told me that Thug plan on killing me, bro. Like, hell nah, man, I ain't never heard of it. Dude, he denied. I'm like, come on, bro. Person will never say, because he was murdered. I don't talk to the police too much. Mm-hmm. You know what I'm saying? So he get nervous. Thug get nervous. Yeah. But I'm saying, why is Thug get nervous if he has nothing to do with anything? Because they obviously look at you as disposable. Oh, see, y'all didn't even say my name. They said.
So the cops are trying to get Woody to talk about Mr. Williams by making claims that they believe that they're making the claim to Woody that YSL thinks you're disposable, you might as well squeal on them. And yeah, this is, and I don't understand. Another thing about the American justice system I do not get. Cops can lie. And there's precedent about it. It's like the only Western country, I believe, that allows cops to lie. And I don't get it. I think it's really, really bad precedent. Yeah, for you who don't know, I will be visiting Atlanta during my US road trip. I will be there around August 14. And I will try to get into the courthouse and into this trial. But I also know there's a risk that Fannie Willis or Miss Love or Miss Hilton sees me and throws me in jail. That's a possibility. I will not visit crime scenes in Atlanta because that's most of Atlanta is a crime scene.
They saying me and Thor. They just like he's saying. But I'm saying like I didn't have no parts to it. And I can't see how scared I was when he held. You feel what I'm saying? Hey, but so he felt like you would tell something. Yeah. Okay, what is there to tell? Huh? What is there to tell? This what I'm telling you. This what he keeps saying. This what I mean. I'm acting like, well, you know what I mean? But see, with the murder, I don't know what you mean. No, I'm trying to explain. With the murder, I act like I never heard about it. You know what I'm saying? I never told T none of it. Period. So I just kept it to myself. So once again, why is he? If Thug has nothing to do with it, if Thug had nothing to he don't got nothing to do with it. What I'm saying is, he got to have something to do with it. All this shit going on, and which means.
I don't think I called Miss Love Satan's hoe. I think I used a much more specific word than that.
He has to have told you something. If he's nervous about you, he's speaking up. He's not listening. I'm listening to you. He's not talking to me, period. He's not talking to you, period, for a reason, correct? Yeah. He thinks because you're talking to us. Yes. He's not saying I'm telling y'all that. He's just saying I'm talking to the police a lot because he heard the conversation in the police had.
Basically, what she's saying is, listen, it's almost like she look at you as the person that brings him down. So therefore, by eliminating you, he eliminated his problem. That's what she's saying.
This what I'm telling y'all. When police detective called, it was a lady. I held the phone in front of her.
Which case was it?
She didn't even say no kid. They just like, now this about my house getting shut up. You know what I mean?
Right.
So when he saw her, he's like, damn, I need to talk to the police. See, he was telling folks different lies. I mean, he told Lil D I'll make Lil D clean never. He's mad at me because he gave me $50 and ain't know what to do with it. What you mean you know what to do with it? Why would he give you $50? Well, this nigga never gave me, you know how much money he ever gave me at one time? Was $1,000. What I mean? That ain't what you said last time I interviewed you when y'all was at the club when they started on you and you came. I get him with a bag. How you give it back if you some money? Nah, that's wrong. Here's money. You getting I'm getting confused. Yeah, you getting screwed wrong. Yeah, let's get paid. Okay. So you give me the money to place it. If it's like this show down.
Then let me get that back.
But the money he give me, the key, is like $1,000. Get the fuck out of it. I don't believe that. I don't have my own car. That's the first time I ever got my car. I don't have a car. What have you done for Thug? Nothing. That's on my mama's soul. You never committed a crime for Thug. I never did none of that for him. So why would he say, look what he against you and scare you? No. That song got the song about little boy you pull up on your pop at your 9. Okay. That's why you.
And we end at 10:25:23.
Well,
All right.
how is the jury supposed to understand Woody in these interview tapes? Can hardly understand him. Well, that is the prosecution has transcripts of the interview, which the defense have indicated that it might not be entirely correct. So, yeah.
I assume.
And no, Judge Level is still not back. This 1 hour recess is now officially 2 hours long.
The next line was Shannon is the shooter. I assume we're taking that out.
Yes.
Okay.
Okay, Mr. Shard or Mr. Steele or anyone else, you want to tell me why it is that you believe that period should, from page 62, line 23 to page 70, line 16 or thereabouts should be, omitted?
I do, Your Honor.
Okay, go right ahead, sir.
That section that are in those transcript pages and what you just listened to have Detective Dennis as well as Detective Gaither injecting their beliefs and thoughts. And by that, I mean Detective Dennis and Detective Gaither told Mr. Copeland that they do not believe him when he claimed that Jeffrey has not given him any money except for $1,000, and that they did not believe him when Mr. Copeland said that he's never committed a crime for Mr. Williams. I also object to the detective. It's both of them. It's first Detective Gaither, then Detective Dennis, saying that their belief is of summarizing what Mr. Copeland was trying to say is that Mr. Williams looks at Mr. Copeland. Mr. Copeland is bringing Jeffrey down or Mr. Williams down, quote unquote, and therefore they latch on to Mr. Copeland when he said that he heard that Jeffrey put a contract on his life or would have him killed. So that's why I'm objecting. I asked Mr. Sharp to include that. I appreciate it. And that's my basis. I believe that I would have a confrontation right. These are thoughts of the detectives that they couldn't testify to themselves in front of the jury because it would be their own speculation. So I'd like that removed. And Mr. Copeland hearsay saying that he heard that Mr. Williams would have him killed. So those are the reasons that those areas are flagged.
All right, sir. Mr. Shard, anything else?
No, I'll just adopt Mr. Steele's objections to that time period.
Okay, all right. State?
And while you're here, hit the like button. You know you can. It's right down there. Thumbs up. That thing and how active you are in chat is what tells YouTube, oh, let's promote this channel to more people. The thumbs up and active in chat. So I don't mind if you do.
This portion is relevant for a number of different reasons. First, starting on page 62, they're getting into a conversation to understand why he is concerned about the fact that he's talking to the police. Where does that concern come from? And he begins to explain a number of different things. First thing he explains is how he learned of the fact that he thought Mr. Williams wanted to harm him. And it's not so much what Valerie told him, but what he did with that information. Even on page 63, he doesn't go into detail about what Valerie told him. She said, I think Valerie told him he's trying to set you up. What he does with that information is he approaches Yek, which is one of our co-defendants sitting in the courtroom today, Mr. Kendrick, to ask him about what he had just learned. And so we believe that this portion, whatever Valerie told him, isn't being offered for the truth of the matter asserted, but the effect on the listener, which is after hearing this, he went and asked Mr. Kendrick about whatever it is that Valerie told him. And then
I mean, that doesn't even come close to effect on listener. Oh, I heard something there. Let's go over here and find out. Did you hear anything? That's not effect on listener. Effect on listener is more, they are after you. They are, I better arm myself and then do a pew-pew. That is effect on listener. This pile of garbage is not effect on listener. Jesus. Ugh.
Kendrick then assured him that that wasn't true, that he isn't trying to harm him. And the jury should be able to.
Oh yeah, about Miss Love being quite a horror in Fulton County, watch my coverage of the Shane Kendall wrongful death suit. I am quite certain that Miss Love has no soul. You can't do that, what she did to Shane Kendall, if you have a soul. Just saying.
Ascertain whether or not they believe that this interaction occurred. Then he goes into why there was a concern with Mr. Williams, and that's about him going to talk to the police too much. And he goes into talking about an incident in which Mr. Williams was present when one of the police officers called his phone. And so that isn't hearsay, that's personal knowledge of this event that took place, that at some point in time when Mr. Copeland was in the presence of Mr. Williams, a police officer called him, and he's explaining.
Called him being who?
Called Mr. Copeland.
Okay.
So Mr. Williams and Mr. Copeland are present with each other. A police officer called Mr. Copeland in his presence. And he's telling the police officers his understanding of what that interaction meant to him. And again, that is relevant as to why he was concerned about why he thought Mr. Williams wanted to harm him. Again, because he was talking to the police too much.
Let me just ask you, just to make it, see if it's clear in my mind. Are you saying that the officer called Copeland and Mr. Williams happened to be present for the phone call?
Yes.
Okay. And that's reflected, at least a portion of it, from what pages?
That is...
Still nothing from the courthouse, and they are fast approaching lunchtime. It is 11:43 a.m. This judge likes to have his lunch around 12:30, and that will take another hour and a half at least. But I'm quite sure they will return to make sure, hey, we're taking lunch now, and then off they F. And if that happens, I will turn this stream down and have a quick nap and a quick bite of food. And then as soon as I see that they are returning from lunch, I will put up a new stream, okay? Because I'm getting quite hungry. I haven't eaten yet since I got home from work. At where I'm streaming from, it is 5:45.
Starting at page 67. Which is line 16.
Madam, do you need some cleaning?
Yes.
Here you go.
Page 16, line 60, page 67, line 16 is where he begins.
Okay, and where does that end?
And it ends on page 68. Line 9.
Okay.
And that's where he says, I'm telling y'all that. He's just saying, I'm talking to the police a lot because he heard the conversation me and the police had. And then he goes in to explain when that occurred. And then it goes into further. They ask him about whether or not Mr. Williams has ever given him money. And he says, no, he's only giving me $1,000 to keep. He's giving me money to flash, but not any money, not any additional money, because they're asking whether or not he's paid for him to do anything. And I think that that's relevant for whatever the jury determines what determines that to be, whether or not they think Mr. Williams is or is not paying him to do anything do anything on behalf of him. And then he goes in, they begin to ask him, why are you mentioning his songs? If you're not doing anything for him, why are you mentioning his songs? Why does he say those things? And they're trying to get an understanding from Copeland, and really trying to challenge his veracity and what he's telling them, Your Honor. And I think that that is important because, again, Mr. Steele's argument has been recently that the police just took everything that Mr. Copeland said and just ran with it without trying to verify it, without trying to test his veracity. And I think this shows that the police weren't just taking everything that Mr. Copeland was saying. They were challenging him on particular portions of the information that he was giving them. And I think that this goes to show a number of different things. The relationship between Mr. Copeland and Mr. Williams at the time of the interview that occurred. Two, to show that the investigators were not just taking what Mr. Copeland said as fact, but trying to test what he was saying, trying to clarify anything that they didn't think, that they weren't sure of. And I think that that is important for the jurors to be able to see the question that they're asking him and the answers that Mr. Copeland is giving, but then to determine how the investigation actually occurred, which is something that Mr. Steele has harped on, is that this investigation was not a full investigation, not a complete investigation. And so for those reasons, I think that this particular section is important and relevant to keep in.
Mr. Weinstein, you wish to be heard since your client's mentioned in this at all?
No problem.
Okay, all right.
I'll just adopt what's already been said.
All right, sir. Okay. Anyone else? Mr. Steele, you have something?
Follow up.
Yeah, go ahead, sir.
I also invoke 24-4-403 on the prejudice side about Mr. Williams supposedly having someone killed. I do not object if the state were to ask Mr. Copeland. I wouldn't object. Was there a time that law enforcement officers called your cell phone or your telephone, Mr. Williams was with you? Tell us what occurred then. Did Mr. Williams react? But they didn't lay that predicate. So I don't believe, again, like I maintain my objection, that they can just play a sequence on June 10th, 2015 and expect there to be just admissible. So I'm objecting to that first predicate. Second part is, I don't object if Mr. Copeland testifies, or if there's a prior inconsistent statement, if he testifies differently, that Mr. Williams was present when the police called. I'm not objecting to that. What I'm objecting to is law enforcement saying, that's not true. I don't believe you that Jeffrey Williams didn't give you money and that you never committed a crime for Jeffrey. And for the state to say, oh, this shows the pushback of the police. It doesn't show the pushback of the police. To me, this shows that law enforcement has their theory and they're donating their theory onto the brain of Mr. Copeland. So I'm objecting to that because it doesn't show anything. Now, if law enforcement went out and we have reports, we have video, audio interviews, we have other witness statements, and they said, hey, we corroborated with X, Y, and Z that Jeffrey Williams put a hit on this man, or that Jeffrey Williams gave Mr. Copeland money to commit a crime. That's real corroboration. But this is not corroboration. This is the police telling the man over and over. It's what he testified to.
Hey, Your Honor.
Hold on, he's not finished. Hold on.
I was lying to the police to get the target off of me. Anything I can do. So I'm not agreeing that the police can then just say through an out-of-court statement, we don't believe you. I think that the jury doesn't get to determine to hear that on what Detective Gaither and Detective Dennis say, because it is irrelevant.
But let me interrupt you just for a second. Isn't that part of the way the investigation occurred? And isn't that what you're also claiming is that they're their method of investigation is not good. I mean, or not as full or proper, and I'm sure you made that argument. You're going to ask that on cross, but isn't that the same kind of first part of the equation?
Well, if I open the door, maybe you change your ruling, if your ruling is in favor of Mr. Williams. But no, this is all the state's doing. The state asked you, you agreed that they could get into without giving us any reports, any statements.
Remember, there's no reports. There's no reports. You've asked me that you've made that statement many times. That's what your assertion is. There's no reports. There's no expert reports or anything like that. This is just their investigation, correct? And I know you have some consternation about that. And I know you can follow up on that too. So,
But their investigation.
Their investigation is flawed, and there's no report to corroborate with what is being said in that interview. The interview videos are garbage because they are not accompanied by reports. The reports are shredded by either the police, the prosecution, or but maybe even by you, Judge Glanville. We don't know because they're gone.
He became, don't tell me what was said, but did you investigate this? And as part of your investigation, what did you find? Well, we found out that Jeffrey Williams is in charge of this criminal street gang. To me, that was a total violation of every reason we come to court. But the state can't now put it on me and say, well, Mr. Steele is challenging the way that they did their investigation. When I cross-examine the witness, maybe it'll change. I haven't cross-examined him. That statement by Detective Gaither and or Detective Dennis, Your Honor, to me, just cripples. It tells the jury the police know something that I have no idea where they get their information from. It's their belief. There's not a scintilla of information in this 8 terabyte of discovery or the trial yet where anybody except the police theory has said that Jeffrey Williams asked anyone to commit a crime. That is all from the mouth of the prosecutors and the detectives over objection. So I don't want this to be included. And then you have a murder. That's a murder. It's not, go and steal that bicycle from the child and then we'll get him a new bicycle. This is the ultimate. So Mr. Copeland is saying, I heard it from another person, the state. I'm going to another argument. The state then says, well, we need that as the foundation for why did Mr. Copeland go to Mr. Kendrick. So to me, to explain conduct, to me, the fact that Mr. Copeland went to Mr. Kendrick to explain Mr. Copeland's conduct, why is Mr. Copeland's conduct matter? It's Jeffrey Williams' character that through totally hearsay statement. Mr. Copeland never says, I confronted Jeffrey and he admitted it in this interview. There are other areas, by the way, that you're not privy to potentially that are on recording where this comes up again, but that's more direct. Right here, this should be excluded to me. And I don't know why it explains conduct where Mr. Kendrick said that's not true. What conduct are we explaining? So I believe effect on the listener is just a way that this prosecution is trying to give you some choice words to have you rule with them. But I would object for all those reasons. And 403. The bottom line is, I'm not saying it's admissible, but I'm saying it's totally the state's theory of the case. And under 403, that should not come in through detectives telling a witness that is a lie. He paid you to commit crime. He gave you money. I mean, to me, I don't know how that should come in on this recording.
What's next for the judge, asks Jay Hampton. Well, we are entering 2 hours and 20 minutes into the judge's 1 hour recess. So he's holding on until lunch, and then he will, hey, let's go to lunch for an hour, which will take an hour and a half at least. But what's next for this judge? Disbarment, I hope. The Georgia Supreme Court yeets him off the bench. and then recommend the Georgia bar to remove his license to practice law. That's my hope. Don't know if we will get there, but that's my hope, because he's done everything he possibly can to show himself a corrupt judge, in my opinion.
May I just address that?
Okay, Mr. T, you done?
Yes.
Okay, all right. Okay, go ahead. Ms.
You're right. Remember, the reason why we're here at the recording to be played again, and I should have started here, is this is all impeachment by contradiction. Again, in court, Mr. Copeland has said, everything I said there was a lie. So one, we're contradicting his in-court testimony by even being able to play the interview. So let's start with the foundation as to why we're even playing the video.
I don't think he said, remember we looked for that? Everything I said was a
Or
lie.
he said that I made it all up. But I recall, I think I asked him on one of my questions, I believe to him, is why would you lie to the police? Why would you lie to the police? If you're trying to get out of jail, why would you lie? I think that I had a line of questioning that said that. But again, in court, he has said, I made everything in my interview up. I just said whatever it is that they wanted to hear so I can get out of jail. So now the jury gets to see his prior statement to see if they can determine, did he just make this all up? Because again, in court, he's trying to say everything I said before, I made it all up. I made it all up so that I can get out of jail. I told the police anything I wanted to tell them so that I can get out of jail. Again, this.
Chico Might says the judge has to know how he looks to the rest of us, right? He can't be that oblivious. He doesn't care about us. He doesn't care about anybody streaming this trial. He doesn't care about Law and Crime or Court TV or local news stations. He don't care. He doesn't care, I believe. He is there for one purpose only: bring this to the end of the trial, get a conviction, and then he will do a meh meh and on to be a corrupt judge on the next case.
Interview is in direct contradiction to what his in-court testimony is. So the premise of why this interview comes in starts there. This is impeachment by contradiction. Once we get
the prosecution wants to enter into evidence gossip. And as you know, I've been watching this trial from day one. Oh, judge is back. Probably just a call for lunch, but who knows? Mr. Harvey looks happy. That's a good sign.
Oh, where's Mr. Weinstein? Okay, all right, okay. All right, thank you, Deputy Ham.
Come on, Judge. Just say I will release
Anybody else
the
joined us
transcript
since
in
the
its
last
entirety.
recess? Other than Mr. Uhalski, who I haven't seen so long, he's grown a mustache. Anybody else? Okay, all right. All right, folks. As you all are made aware, last week the court was going to do an in-camera review of the ex parte proceedings on June the 10th of 2024. In considering whether or not to have an in-camera discussion or review of the records, this court has decided to release the entirety of the transcript of those proceedings as courts one. And I'm going to take judicial notice of the following timeline. On Friday, June the 7th, 2024, Mr. Kenneth Copeland was granted immunity from prosecution pursuant to 24-5-507A, and that'll be marked as courts 2. So the transfer will be court 1. His immunity agreement, Mr. Copeland's, will be court 2. Mr. Copeland, who was represented by Mr. Jonathan Melnick and advised of his rights and obligations during the proceedings on Friday, June the 7th, which will be marked as courts 3, the transcript of those proceedings, Mr. Copeland invoked his Fifth Amendment privilege and was held in contempt, and that will be courts 4, Mr. Copeland's order of contempt. Mr. Melnick informed the court that he was not going to be in attendance of any further proceedings as he would be on leave effective 10 June of 2024. The court informed Mr. Melnick that
Yeah, isn't that convenient that the prosecution knew well in advance, because he told them last summer where he was going to be the next year. And as Gigi says, he says it is the entire transcript. How will we know for sure? Because so far he's been holding on to it. And yeah, exactly. I don't trust this guy at all.
his leave, or I had discussions with him that his leave was not proper and that he needed to be in attendance on Monday, June the 10th of 2024 with Mr. Copeland. Mr. Melnick relayed that attorney Caleb Bumpus would be representing Mr. Copeland. On Monday, June the 10th, before court, Mr. Edward Chamberlain, the court's litigation manager, informed the court that the state wished to have an ex parte meeting with the court. No subject matter of the ex parte meeting was told. The entirety of the ex parte hearing held on the 10th of June of 2024 was taken down by Ms. Christina Weaver, the court's official court reporter. This ex parte hearing was held in chambers starting at 9:10 a.m. Present along with the court were Ms. Kayla Bumpus, attorney or ADA, Ms. Adrian Love. Also present were the DA's investigators, Mr. Long and Mr. Hamilton. The ex parte hearing stood in recess from 9:34 to 10:03 a.m. to await Mr. Copeland's arrival. The ex parte hearing resumed with Mr. Copeland present at 10:03 a.m. Also present were attorney Bumpus, Ms. Hilton, the DA's investigators Long and Hamilton, the court and security personnel, deputies Houston, McPherson, Brown, Sergeant Brown, and Sergeant Hall. The ex parte hearing stood in recess to allow Mr. Copeland to have a private conversation with attorney Bumpus from 10:17 a.m. to 11:28 a.m. The ex parte hearing resumed at 11:28 a.m. The ex parte hearing concluded at 11:31 a.m. The court arrived in courtroom 1C at 11:49. That will end
Yeah, but when did you decide that this would be a secret from the defense? You haven't said that yet.
transcript of those proceedings starting as of 11:49, or when the court presumed that held the proceedings on 10 June in courtroom 1C 2024. That will be marked as courts 5. The proceeding in 1C commenced on the record at 11:52 a.m. A lunch recess was had at 12:51 p.m. The parties returned from lunch, and Mr. Steele informed the court that he had a motion, and that was at 1:46 p.m. In asking then Mr. Steele later that afternoon was held in contempt. However, he was allowed to continue representation of Mr. Williams. The court, in asking Mr. Steele questions of how he received the information that he proffered in open court, was only concerned about the integrity and security of the conversations that were had in chambers, not whether those conversations were the subject of proper ex parte conversations or the sum and substance of.
Oh, you BSer. You absolute BSer. This is Judge Glanville backpedaling like a maniac, trying to justify for himself and for appellate issues his conduct. You threw a tantrum at Mr. Steele because you didn't want anyone to know about, as you didn't want the defense to know about this ex parte meeting, and you threw a tantrum about it.
What was told to him at that time. Jurors Jurors entered the courtroom to resume Mr. Copeland's testimony at 3:39 p.m. The jurors were excused and exited the courtroom at 5:56 p.m. Mr. Copeland was excused and exited the courtroom at 5:58 p.m. The court asked Mr. Steele again whether he received ex parte information, and that would be at 5:59 p.m. Mr. Steele's counsel, Ms. Ashley Merchant, and Mr. Alex Susor entered the courtroom. Mr. Steele was held in criminal contempt. That order of that contempt will be marked as Court 6, and the proceedings concluded at 7:41 p.m. The court further takes judicial notice of the following statements proffered by Attorney Steele, Brian Steele, in open court upon information and belief stated to the court, which are still unknown. There are 6 assertions that Mr. Steele proffered in front of the court. Those are contained within the transcript of Courts 5, the proceedings that are held on the 10th of June of 2024 in courtroom 1C, which the court has already said will be part of this order. The first assertion
I don't trust him, because if he now goes on to claim that this assertion from Mr. Steele is false, it's not on the record, I will assume it's not in the transcript because Judge Glanville took it out. Oh, my banner is not current. Sorry. Thank you for reminding me.
and the transcript bears out exactly what Mr. Steele said. So the court is paraphrasing the 6.
Mr. Steele, am I hearing this correct? The judge is admitting that Mr. Steele's assertions were completely correct. Wow.
Assertions that Mr. Steele made, they're more aptly and more eloquently put in the record. The first one involves his concern that supposedly in chambers, this honorable court reporter, court at times, district attorney or district attorneys before the DA's office, as well as investigators, sheriff, and deputies, Mr. Copeland and his counsel met together. None of the defense team, to his knowledge, were present. Second assertion he makes is that Mr. Copeland intended to plead the Fifth Amendment. Third assertion is that Mr. Copeland, as a party was sworn, and Mr. Steele asserted that this particular conversation was in fact a critical stage, and that the defendants had the right to be present. The fifth group of assertions involved Mr. Copeland not going to testify. The fifth group of assertions involved what Ms. Attorney Hilton claimed or said to the witness, to include the court, involving allegations of coercion and witness intimidation, and that his counsel had the right to be present. And the sixth assertion that was made in open court was that Mr. Copeland admitted to killing Donovan Thomas. At some point after Mr. Steele was held in contempt by this court in the afternoon of June the 10th, it was brought to the court's attention, not at the court's request, by security personnel that video footage of what occurred outside courtroom 1C shows the interactions between Ms. Bumpus, Mr. Steele, Mr. Adams, and Mr. Sharp. The court in no way sought to investigate any facts of this involving this footage, and only considered it for the security and timeline of events that occurred on June the 10th of 2024. Also, in no way did the court consider any of this footage in holding Mr. Steele in contempt. And as I said, mentioned it only for the purposes of considering the security and breach of information that occurred within the court's chambers, not for whether or not that was truthful or not.
Everything Mr. Steele asserted or in court by information and belief, everything was true. Yes, JMK. Woody was sworn in at the time. Still a sworn in witness. Which means, just as examples, that Woody was going to plead the fifth again. Then he said he was going to lie in court. Miss Hilton gave him immunity if he lied in court. She wouldn't prosecute him for committing perjury. Then Woody said that he is the one who killed Nutt. And then Hilton said, if you do that, I will prosecute you. This is coercion. This is textbook coercion. This should be an immediate mistrial. When the judge had the knowledge that the prosecutor was more or less directing Woody how to testify and giving immunity for lying on the stand. This should be an immediate mistrial with prejudice. Immediate. Witness tampering.
Mr. Steele makes further made three assertions on the 10th of June of 2024. One, he asserted that this was, on behalf of Mr. Williams and similar situated individuals, that this was, the court held an improper ex parte meeting. Secondly, that Mr. Copeland was a sworn witness and this was a critical stage. And no, Mr. Copeland was a sworn witness. And third, that he argued that this was a critical stage and that he and the others needed to be present at that point in time to pursue the Sixth Amendment rights of the defendants in this case. As to Mr. Steele's first assertion of whether or not the court held an improper ex parte meeting or hearing, the court is guided by Judicial Code of Conduct 2.9, which I'll take judicial notice of, which in pertinent part, where circumstances require ex parte communications are authorized for scheduling, administrative purposes, or emergencies that do not deal with the substantive matters or issues, provided that the judge reasonably believes that no party will gain any or procedural, substantive, or tactical advantage as a result of the ex parte communication. And the judge makes provisions promptly to notify all parties of the substance of the ex parte communication and gives the parties an opportunity to respond. And in this particular circumstance, the transcript of these proceedings was just prepared and is final by my official court reporter, Ms. Weaver. And all counsel will be, as I said, given an opportunity to, as soon as the court finishes entering this order, it will.
You try to conceal this from the defense. You cannot backpedal from that.
Be e-filed, so everyone will have a chance to take a look at it.
As soon as this
and
is
use it
public,
as they see
I'm
fit.
going to do a video reading on the transcript.
In this particular, and then the last part of 2.9 before the court goes on, if involves in pertinent part, if a judge inadvertently receives unauthorized ex parte communication bearing upon the substance of the matter, the judge shall make provision promptly to notify all parties of the substance of the communication, provide the parties with a reasonable opportunity to respond. And as I mentioned earlier, I'm going to release the entirety of the transcript to you all to use as you see fit and before any other further examination of Mr. Copeland. I'll address the issue of the emergency nature of this particular hearing or this particular conference in front of the court.
More backtracking.
Is that this involves the state's concern as to what Mr. Copeland was in fact told.
None of this is excusable for you to not inform the defense. None of it, Josh Glanville. None of it. And you can see it on him. He looks completely defeated. Completely defeated. This was not an emergency hearing. This was just the prosecution wanting you to join in on the coercion of Woody to lie on the stand.
By his counsel, Mr. Melnick, and his understanding of the immunity agreement pursuant to 24-5 507. And that the conversations that were had in the transcript will bear out that no tactical or other advantage or any testimony that was stated during that particular hearing would be anything other than the court and or the state communicating, along with Ms. Bumpus, his lawyer, who's there the entire time, his witness's understanding of his immunity agreement. In consideration of this emergency nature, the court is.
Remember, folks, you have to remember this. Josh Glanville said numerous times these past 2 weeks, 3 weeks almost, that he wouldn't give anything out until after the trial. And now he's backpedaling like a maniac because he started to realize, especially after the Georgia Supreme Court denial of the writ of mandamus. In that denial, they specifically wrote out how this should be handled by the lower courts. And if they don't, the appeal will go right up to Georgia Supreme Court. And what I read there, they were unanimous in this, Georgia Supreme Court. They, in my opinion, will bring down the hammer hard unless the lower court actually starts doing their job.
Taking into account a couple of cases I'll cite for the record. One of them is United States versus Adams, and that's 785 F. 2nd 917, decided in March the 31st of 1986. In pertinent part, presence of the accused. Although an ex parte conference to discuss threats against the witness is proper, District court must ensure that the conference is carefully conducted so no rights of the defendant are threatened. Presence of the accused. Ex parte conference between judge, prosecutor, and government witness to discuss refusal of witness to testify because of his fear of reprisal was not improper, where substance of the inculpatory testimony was never discussed and the entire conference was transcribed. And in Adams, the appellants contend that the ex parte conference was improper and it violated their due process right to a fundamentally fair trial. We agree with appellants that ex parte conferences should occur, but rarely, especially in criminal cases. This does not mean, however, that such conferences are unconstitutional. Indeed, some situations, the trial judge may find an ex parte conference necessary. Cite La Chapelle, and that's LACHAPPELL versus Moran at 699 F. 2nd 560. It's a First Circuit case from 1983 where the court cites, in the exercise of the court's residual power to ensure a just trial, protect jurors and witnesses, a judge may, in rare circumstances, feel it necessary to confer with a juror or witness on the record, but outside the presence of others, including the defendant. One such conference may be where a juror or witness, having been threatened, wish to speak with a judge privately about a threat. A witness may not feel free to discuss any threats in presence of the defendant or even counsel for the defendant. We agree that the First Circuit, that an ex parte conference is appropriate in that situation. They see United States versus a.
Yeah, what the judge is doing now, he's reading his defense of his misconduct into the record. What you're watching right now is Judge Glanville trying to save his future as a judge. He knows that if he doesn't do this flawless, within months, he's going to be yeeted from the bench. Now he's attempting to bring in, witness was being threatened in some shape or form. Woody stated clearly he's not scared of the defendants at all. This is so pathetic.
Royo, and it's ANGULA. It's at 580 F. 2nd 1137, pinpoint 1142, 1142, and 1141, 1142, Second Circuit case.
He was
Exclusion of certain defendants and counsel from in-camera proceedings permissible in multiple defendant trial, where certain defendants had cooperated with government and received death threats. And they've got a citation for that being 439 U.S. 913. Although an ex parte conference discussed threats against witnesses proper, the district court must ensure that the conference is carefully conducted so no rights of the defendant are threatened. In this case, the court followed procedures to ensure the conference was fair. First, at no time was the substance of Pooley's inculpatory testimony discussed, and second, the entire conference was transcribed. And that's United States versus Watchmaker at 761 F. 2nd 1149, 1985. Ex parte conference with frightened juror properly were transcribed and the judge's comments carefully framed. This court goes on to say in Adams, two aspects of this conference, however, disturbing. First, when the prosecutor began to impress upon the witness the distinction between being paid for testimony and afforded protection, the trial court should have called the conference to a close. The portion of the record quoted above indicates an attempt by the prosecutor to coach the witness on how to answer questions about inducements from his testimony. The court had already learned all it needed concerning the witness's fears and the prosecutor's plans for protection, there being no reason to participate in such coaching. Second problem occurred where Pooley took the stand. Defense counsel inquired about what inducements had been given for Pooley's testimony, and the prosecutor and Pooley both indicated the promise was the prosecutor would seek to enroll Pooley in witness protection program if he were in fear of his life. Neither related to the prosecutor's pledge to seek immediate protection for Pooley should it be necessary. The exchange occurred before the court, and the court should have made sure that the inducements made as in the ex parte conference were completely and precisely disclosed. Similarly, in this matter, the only thing discussed between the state counsel for Mr. Copeland, and this court with the understanding of his immunity agreement. There were no other testimonial statements made by in terms of what Mr. Copeland planned to testify to, that were induced.
You just said a few minutes ago that more or less everything Mr. Steele asserted upon information and belief was correct. And now you're here saying, oh, that didn't happen. Yeah, Counsel of Copeland says differently. I mean, this will be an additional Foster clock, an additional, because if, at this moment, if Miss Kayla Bumpus, right, we already read her affidavit. If she extends her affidavit on what was actually said, Judge might just have perjured himself into the court record.
Or sought by the court, and the transcript in its totality will bear that out, and you can have a look at that. The court's also considered Bruner versus the state. That's 302 Georgia at 6, and this relates to the right to be present and what is defined as a critical stage and under the 6th Amendment. Bruner contends that he was denied the right under the Georgia Constitution to be present at certain critical stages of his trial proceedings. Embodied within the constitutional right of the courts to a criminal defendant's right to be present and see and hear all the proceedings which are had against him on trial before the court. Ward versus the state, 288 Georgia 641, pinpoint 645. Violations of this due process right are presumed prejudicial absent a waiver by a defendant requiring a new trial. However, there were no violation of Bruner's right to be present. The right to be present attaches to any stage of a criminal proceeding that is critical to its outcome if the defendant's presence would contribute to the fairness of the procedure. And that's Huff versus the state, 274 Georgia.
Woody was a sworn-in witness who was about to plead the fifth. And then in that hearing, he told to everybody he was going to lie on the stand. And Miss Hilton offered him immunity even for lying under oath. That is quite critical. You can't backpedal away from this, Judge. This,
110, pinpoint 111. Thus, a critical stage of a criminal proceeding is defined as one in which the defendant's rights may be lost, defense is waived, privilege is claimed or waived, or one in which the outcome of the case is substantially affected in some other way. And in this particular case, the court is of the opinion, basing on the case law, that
I will remind you, without this Donovan Thomas murder charge, everything in this RICO case falls apart. Why? Because murder has no statute of limitation. The statute of limitations has run out on most of everything else in this RICO. The only reason they can keep all the other charges in is because of the Donovan Thomas murder charge. Without it, if that is tossed, then the statute of limitations applies to each and every one of the other charges, overt acts, and underlying acts. And then 80-90% of this case is gone. Carjacking, I believe, is 6 to 7 years statute of limitations. Shooting a gun, 5 to 6 years. I mean, most is between 5 and 8 years statute of limitations of everything else. So without this witness, Mr. Copeland, Woody, without him testifying, the entire RICO case falls apart.
that this was a proper ex parte meeting pursuant to Rule 2.9, as well as the no party gained any tactical advantage, and that the proceedings as a whole are released to will be in the terms of the transcript. So what was said can readily be seen and utilized by the defendants. Okay, and the court lastly took into consideration Talton versus the state. That's 368 Georgia Appeals at 313, and that involves a Sixth Amendment critical stage definition that was decided June the 21st of 2023. And in pertinent part, in many instances, remand will be necessary when the right to be present claim under the Georgia Constitution is raised for the first time on appeal from criminal conviction. So Mr. Steele's raised this at the appropriate time, and the court is in fact considering it. And the Georgia Constitution guarantees criminal defendant to be present, see, and hear all proceedings in which are against him on trial before the court. Criminal defendant's right to be present under the Georgia Constitution attaches to any stage of the criminal proceeding, which is critical to its outcome if the defendant's presence would contribute to the fairness of the procedure, but the right does not extend to situations where defendant's presence would be useless or benefit but shadow. And under the Georgia Constitution, defendant who is represented by counsel need not be present for portions of the trial that involve questions of law and consist of essentially legal argument about which the defendant presumably has no knowledge. It is well settled under the Georgia Constitution guarantees the criminal defendant the right to be present and see here all the proceedings in which are had against him or trial before the court. It's Prickett versus the state, 314 Georgia, 435 at 441 pinpoint. This right attaches to any stage of the criminal proceeding that is critical to the outcome if the defendant's presence would be contribute to the fairness of the procedure. But the right does not extend to situations where the defendant's presence would be useless or benefit or shadow. The court further takes no position on whether Attorney Bumpus disclosed confidential or attorney-client matters. The court takes no position on whether Attorney Bumpus violated the duty of candor to other counsels involved in this case. These two questions can be resolved by the State Bar of Georgia and or our Supreme Court. The court further takes no position on whether Mr. Steele, his use of the June 10th proffered information as his use on behalf of Mr. Williams falls within our guidelines as set forth in the Georgia Rules of Professional Conduct. The court's basis for having been explained on the record, a written order of this along with the attachments will be included in the record. And Mr. Banks, where are you? Sir. As a result of this transcript release, the court withdraws the show cause for your client and others who may be present who are present in chambers on the 10th of June of 2024. And as I mentioned earlier,
it withdraws the show cause meeting, which means Ms. Bumpus does no longer risk contempt of court. This judge is backpedaling so hard that he is more or less smashing his head against the tile in the pool. It is so pathetic to see. It is so utterly pathetic to see this judge trying desperately and pathetically justify his actions. That's...
we were going to have a show cause hearing on Wednesday, the 3rd of July. I am canceling that indefinitely. In fact, I've canceled all of that. So we will not be holding that particular hearing. Okay. All right. And then then transitioning to the last matter the court wanted to put on record, upon further review, this court will in fact enter an order sending Mr. Adams and Steele's, Mr. Weinstein and Mr. Banks' motion to recuse to another judge pursuant to Uniform Superior Court Rules 25.1 through 25.7.
Yeah. What should have been done all along? You backpedaling on this as well only shows how much misconduct you have done throughout this entire trial. And you admit that you have done wrong for months on this. months.
in the method and manner prescribed by our local rules. So this written order is entered. I will enter the order transferring it. And until such time as those two things are decided, then we'll be in recess until that time. And we will just inform our jurors that they're until they're not supposed to come back on Monday until Monday anyway. So I will have Deputy Ingram and Ms. Umana indicate to them that they are still on recess and we're continuing to work. So that's all I have for you at this point in time. Okay? All right. Ms. Novi, can I ask you a question before you start anything? Madam, didn't your law firm represent one of the co-accused in this case? How are you then? Do you have an actual or perceived conflict in this case? How?
And after all of this fake, humble thingy, he immediately tries to assert, oh, you lawyer over there, you did misconduct, didn't you? Oh, this is unreal.
Have you been, I'm asking at this point in time, could you state for the record how it is that you don't think you have a conflict? Because you did represent one of the co-accused in this case, correct?
I did.
Okay.
I did. Your Honor, this has absolutely nothing to do with my representation of Sergio Kitchens. Haven't even discussed that or come up and what happened in the ex parte proceeding. We're just representing Mrs. Bumpus, Attorney Bumpus, in what her position is with respect. Is on mute?
Yeah, you're good now. Yeah.
With respect to this court. So completely different matter. And now we're dealing with a contempt hearing of Ms. Bumpus as opposed to a criminal prosecution of Mr. Kitchens. Completely different. And in fact, everything that we've gone through or anything we've learned about this case has nothing to do with what we've done with Attorney Bumpus.
Okay, I just want to, because you may have an actual or perceived conflict. I just wanted to bring that to your attention. So if you think that it should be addressed, then I'm giving you the opportunity to do so at this point in time. Because you do have knowledge of this particular case, but all right.
Well, I think half of
else?
America has
I'm sorry?
not. I said, I think half of America has knowledge of this particular case at this point.
But they're not before us at this point in time. So what else did you want to?
Well, and I'll speak from.
Hello. International coverage of this absolute scam you're running here, Judge Glanville.
For the court's purposes, I'll speak for myself and John Garland, who's also our co-counsel with Attorney Bumpus and who was my co-counsel in Mr. Kitchens' case.
All right.
So I'll speak for both of us in that respect since Mr. Garland's not able to be here.
All right.
A couple things that I just wanted to clarify for Your Honor. Is the court still intending to produce an order on what the court addressed orally on our recusal motion?
Yes, ma'am. I'm going to produce an order basically bundling all, since there are 3 motions to recuse, to one to be spun on the wheel so that we don't get 3 separate people hearing these particular matters. So I will do that effective today. Okay. So does that answer your question?
It does with respect to that. The other issue was I think the court was holding under advisement our motion to quash.
That makes this moot at this point in time.
Okay.
So since I'm not going to have a hearing at this point or at any time in the future, you can re-raise it at that point in time if you so desire.
That's fine. So
I'm telling you at this point in time, I have no desire to resolve that. I don't need to at this point in time.
Okay. All right. Those are the questions that I had.
Okay. All right. Madam, unless you have anything else, you all can be excused. Counsels, I'm going to go ahead and, like I said, work on this particular order. I actually memorialized the order in writing and the motion to recuse in terms of sending it to another judge pursuant to 25.1 through 25.7. And we'll see in a little bit, depending upon how it's ruled upon. All right. All right.
Your Honor, do we have a timeline of when the motion to recuse may be heard?
Don't know. That has to go to another judge pursuant to our local rules. So it will be basically put on the wheel. Of course, I don't have anything to do with that. So as soon as our clerk, Madam Clerk, Ms. Alexander and her team spin that, that's not within my information and purview.
Is this something that we can expedite? I mean, the state does have very concerns that we hold the jurors indefinitely regarding this matter. Is there anything that could be expedited so that those decisions can be made on the motion to recuse and we can move forward with trial?
While I understand your concern, I think the rules of transfer and recusal are pretty clear that I'm not going to comment on anything that is pending at that point in time. So hopefully it will get done fairly quickly in terms of somebody acting on it. Okay.
All right, thank you, Your Honor.
Okay. Anybody else? Mr. Steele, you rose just a second ago. Do you want to say something, sir? Okay. All right. Okay. Okay, then we're in recess and we'll see you in a little bit, okay? All right, we're in recess.
Wow. So we now know that more or less everything Attorney Steele said in open court is true. Now, we don't know until the release of the transcript what is actually said. And looking at Judge Glanville's conduct for the past year or more in this case and trial, I wouldn't be surprised if Miss Bumpus comes out and says about this transcript, somebody left things out. I wouldn't be surprised at all. But we don't know yet. Until that transcript is public, I would assume it goes public quite fast. When it goes public, I will get a hold of it. We will read it live on stream when I can. I'm not entirely sure what this means for the rest of the trial. Do they have to wait until the judge in the lower court finds for or against Judge Glanville before the jury trial can commence? They will probably still be having hearings about evidence and stuff like that, but I don't believe they can continue the actual jury trial until the decision is made if Judge Glanville should recuse himself. That is my understanding of it as of now. Dave, I would love to hear your input about this. Dave over at Making Law, MLS Code of Law. You know a lot of what's been going on. I would love to do that reading of the transcript with you if you have the time once it gets out. Yeah, but as everything is fine, there says sounds like everything is frozen. Bumpus is live on the lead attorney. All right. Then I will actually do like this, but I don't believe I can redirect to the lead attorney. Come on. No, he still doesn't allow redirect. Get over there, folks. I need to eat. I need to get some rest. Oh, speak of the devil. Hold on. There.
Hello, hello.
Hey.
So the judge finally decided to follow the rules and send it off to another judge, huh?
Yeah. First, he admitted that more or less everything Attorney Steele said in open court upon information and belief was correct. Now we don't have the transcript yet, so we don't know exactly what will be in that. But he more or less asserted, yeah, he was correct. So now he's been backpedaling about everything he has done for the past 3 weeks. On what happened on June 10th up until now, everything he's been trying to backpedaling. And I understand why. His career as a judge is on the line.
Oh, very much so. Very much so. Whatever it is, there's a governing board. In Michigan, we call it the Judicial Tenure Committee. But whatever it is looking into this. The fact that he held Steele in contempt, and
by the way, Steele's contempt wasn't purged because that was the sentence already in place. He can't go back on that.
Yeah.
Wow.
Yeah. So his future as a judge is definitely in question right now.
Yeah.
Gigi said wanted to know if I could hop on and answer some questions. I don't I don't know exactly what the issues are, but I'd be happy to. I have a few minutes.
Well, with this ex parte meeting, which now Judge Glanville, he did that. All the rule says, oh, I don't believe this was a crucial part of the trial and nobody gained an advantage of this, which is absolute bullcrap because the murder charge has no statute of limitation. If that is gone due to Woody not wanting, then all of the other charges statute of limitation applies. And we are talking about 2013, 2014, 2015, 2016, alleged home invasion, having a gun,
Yeah, I mean, it's
stealing a car.
imagine
drugs.
this situation where the judge is just walking down the street and the judge sees a murder take place.
Yeah.
Then the police arrest the suspect, charge him with the crime, and that very same judge is assigned the case. That judge can't be a witness and the judge. The judge
No.
must recuse himself because the judge is a necessary witness, right? We can all get behind this idea, right?
Yeah.
So when the judge had this ex parte meeting with the witness who allegedly confessed, now the judge it's as if he stood there and saw this murder happen. He's now a necessary witness. He cannot be a judge. And so take away the whole ex parte thing. He's potentially an impeachment witness for this for what's his name that was going to take the stand or did take the stand.
Woody.
Yeah, I mean, so you have that to start off with. Then you have the ex parte communication, which is a huge no-no for judges. So does that create an impression of bias? Yes, it does. Just the appearance of biasness is created at that point. Does it create a realistic or an actual bias? It could. Why was the defense not noticed? Maybe there is actual bias, right? So for those two reasons, the judge needs to be removed. And then on top of it, when he's called out about it, then he goes and punishes the defense attorney who's asking about it. So that is another sign of bias. So for the biased reasons, at least 3 signs of bias, and for the necessary witness part, this judge needs to be off this case.
Yeah, but then comes because the state asked, because the judge acknowledged that the state asked for this ex parte meeting. Could this be a reason for a mistrial with prejudice?
See, that's the thing is, well, not with prejudice if the bad actions fall to the judge or anyone other than the prosecutor, right? Anyone other than the prosecutor.
Well, according to Attorney Steele, prosecutor, not Love, the other prosecutor, damn, I lost the name all of a sudden. The other prosecutor, when Woody said in this ex parte meeting, he's going to plead the fifth, and then it was coercion for him. No, if you do that, I will hold you in contempt until the last of the trials are done with the other defendants who are severed from this case. We are talking about 5 to 10 years from now.
Mm-hmm.
Then he said, well, I'm going to lie on the stand. And then Prosecutor Hilton allegedly said, I will give you immunity from prosecuting you for perjury if you lie on the stand. And this is in judge's chambers. Then he said, well, then I killed Donovan.
So,
and
so that statement, if it's in the transcripts, that statement could lead to a mistrial with prejudice, but not the mere fact that the prosecutor was involved in the ex parte meeting. By the way, it should have never been an ex parte meeting.
No.
You can do that out in the courtroom, on the record, not in front of the jury.
Yeah.
So you can do all of those things on the record.
Yeah, and now when the judge has tried to backpedal 3 weeks of his conduct, but that doesn't really matter because his conduct has been going on for, according to me, for months.
Oh, it has. It has. It just The problem is that we've seen this judge's conduct, the way he approaches the prosecution versus the way he approaches the defense. That's generally not enough. It should be enough in many circumstances, especially the prolific nature of it. But generally, that's not enough. What you need is a judge going to such extremes that even like there's no doubt that this judge is acting improperly now, right?
Yeah.
And that's the problem I have with a lot of these situations is you can have a completely biased judge, but it's a feeling. It's in his tone. It doesn't come across in transcript, right? And when you only have that sort of feeling, it's hard to get the judge removed. I think it should be a lot easier. But then in the other case, you know, if it was a lot easier, then you could effectively have jury or judge shopping and things like that. So there's a fine balance that they're trying to make here. But this judge has acted improperly towards the defense the entire time.
Yeah.
And
I can count from memory 3 times where he told the defense attorney he was acting unprofessionally in front of the jury.
Yeah.
And
There's things like that could amount to a mistrial just in and of itself, because now the jury's been tainted, a statement's been made in front of the jury. But this judge was never going to order a mistrial.
No.
It's going to require his hands being tied. It's going to require another judge stepping in saying, this judge is either a necessary witness or biased or both, but either way, this judge needs to be off the case, and that's going to trigger an automatic mistrial.
Yeah, I can't see how this can turn now. So the issue is here: does it reach the level of mistrial with prejudice or not? And that, I mean, that is an extremely high bar to reach. That simply rarely, if ever, happens. It's as unusual as a what's it called? The
directed verdict.
Directed verdict. But I already had one of those in my streams. So,
yeah, right. You might get another.
I'm good.
You might get another anomaly. Just keep covering this case, and we'll get a mistrial with prejudice. So the issue is the courts don't want to necessarily tie the prosecutor's hands on issuing a retrial. They don't want to say, "Well, it wasn't the prosecutor's fault for a mistrial, but you still can't try him again," right?
Yeah.
If they don't find enough fault with the prosecutor requiring the mistrial, and it's not going to be out of this. If it's declared a mistrial because they changed judges, the prosecutor's going to be off the hook and they're going to be able to bring new charges.
Yeah.
Once the new judge is on and the prosecutor tries doing these things, like the judge that did the whole voir dire thing with what's her name? That prosecutor, the elected prosecutor.
McAfee.
He's not going to tolerate a lot of this stuff. And so if it's him, and if the prosecutor keeps trying to do some of these things, and as a result, they have to declare a mistrial. Now, this is a year down the road before they start a trial again, right? So if that happens, then I could see it being a mistrial with prejudice. But it's going to take a whole another trial to start. That's my prediction.
Yeah. Now, for a more fun speculation. If we can conclude that George Glanville colluded with prosecutor Love and Hilton and prosecutor Forney Love or Forney Willis, you have 2 or more people in a criminal enterprise. Don't you have that?
Yeah.
Could this be RICO?
Yes, you do. Pots and kettles, right?
Yeah.
That's great. Yeah, you do for sure. So okay, so they get a new judge to look at this, and they say that this judge has to be off the case. They order a mistrial. They start the whole process again. Those transcripts are still out there. The defense is going to be filing motions And if
Yeah,
they don't
because-
think that the transcripts are complete, or for whatever reason, they might even want to depose. I don't know if depositions are allowed in criminal trials in Georgia. Might want to depose the court reporter regarding this. They might have some motions regarding that. But if they uncover any sort of connection between the prosecutor and the judge with regard to this ex parte communication and that the prosecutor was in on it, they might file a motion for dismissal with prejudice going forward. We'll have to wait and see. This is going back to almost an evidentiary gathering part of the trial.
Yeah, because if I remember correctly, I think the trial was 3 weeks. No, this was pre-trial. The first time they asked for, to dismiss the case because of something, and the judge denied it. And then they asked for a certificate to appeal this, and the judge refused it. And at least 24 times, the judge has denied them a receipt to send it to the appeals court throughout this entire trial.
The prosecutor could be conducting or could be committing misconduct. Depends on how it just depends. I don't know enough information. I can theory craft situations where the prosecutor is committing misconduct. I can also conceive of situations where they might not be. If, for example, the judge says to the prosecutor, I'll go ahead and inform the defense once we go back on the record, or something along those lines.
I just realized, since the show cause hearing is mute, he no longer an issue. Kayla Bumpus is now completely off the hook. And if the attorney-client privilege doesn't apply, she can talk all she wants, unless it's very specific to her about her client.
Well, yeah, attorney-client privilege goes with you until you're dead as the attorney.
Yeah, but regarding the ex parte meeting, because everything that was said in that ex parte meeting was written down.
Oh, yeah.
Yeah. So whatever happened, she's free to talk about it. And he fired her.
Because the whole judge's order about you can't talk about this thing, that's gone.
Yeah. No, but there was no order in that ex parte meeting. No order of secrecy, no order of shut the F up, no order of anything. Just the implication, my chambers are sacred kind of thing, which is BS. Unless it's
okay,
on
so
paper,
there
it
are
doesn't
mechanisms.
exist.
There are mechanisms in order for a judge to interview an individual. We in chambers without anyone around and no record of it. There are, I don't know what the procedures would be in Georgia, but in Michigan, for example, if you had a juvenile, particularly in the family law, domestic sort of situation, but they have these things called in-camera interviews. And the judge is not free to disclose what's said, but can say, I sat for an in-camera interview with this particular child, and I took that into consideration when I made my opinion. You can't divulge what was said. There are very, very, very limited circumstances. I don't know of a situation where it would apply to an adult witness, but there are mechanisms set up, and maybe there could be an argument for something, but it would be, I couldn't justify it with a witness, especially a witness that's getting immunity. All of this should have been done on the record.
Yeah. He could have saved himself until the end of the trial by just having this on the record.
Yeah.
But he chose not to. And that tells me he has done this numerous times before. Ex parte meetings with the prosecution.
Yeah.
It's a habit.
And you can't meet with one side without the other side. Ex parte communication is literally communicating about the case with only one side present.
Yeah.
And the ex parte, no party on the other side. That's a problem.
Yeah. And even if it's about scheduling or any of the other exemptions, you still have to notify the other side.
Yep.
So I don't see him getting away. But also, there are about a dozen severed defendants in this RICO trial who will be tried later on. Again, they might not try to get the entire RICO, but if they get the murder charge dismissed, because Woody is the key witness. Nothing else matters because he is the only one who actually points to people. The attorney or former prosecutor Sprinkle.
Sprinkle.
Yeah,
Yeah,
his name is Sprinkle.
I remember that.
He dropped the charges twice on the murder of Donovan Thomas against different defendants because there was no evidence. And he is yet to testify. And so there is a good argument if the coercion against Woody is on that level. And if they dismiss the murder charge, the entire RICO case is gone. Because now they have maybe a handful of cases from 2016 whose statute of limitation hasn't run out, 2016, 2017. Everything else is between 2013 and 2015.
So Gigi wants to know if there's a way to find out if the judge has done this with other witnesses. If the Judicial Tenure Committee or whatever the agency is that oversees judges starts an investigation, they could look deeper into that. There was a Michigan judge here.
Yeah.
She ended up, here's a good example. Her husband filed for divorce because she was having an affair. The case was assigned to her, and she didn't recuse herself immediately, and in fact sat on it for 24 hours before she recused herself. During that time, deleted a bunch of text messages and emails and told a bunch of her staff members to hush up. Then eventually recused herself. Well, the person that she was having the affair with was a lead investigator on a murder case that she just tried like not 3 months prior. And so that opened up a whole can of worms into that investigation, which then opened up a whole can of worms into the prosecutor's office, because apparently she's having hot tub parties with prosecutors. And like everybody went down, like the whole prosecutor's office was cleared out. There were so many people from the state police department that were cleared out. This judge went to prison. And so once they started diving, they did a deep dive. So there is a situation where that could happen.
Yeah. And now this is more or less confirmed. Now the Young Thug trial is paused until a different judge decides if Judge Glanville should be removed from the case. And even if this judge, depending spin on the wheel, who gets it, say that person said, no, he did nothing wrong, that will be appealed immediately. And the Georgia Supreme Court, in their denial in the writ of mandamus, they lined out, this is how you do it. It is really spelled out. So I assume that if anyone on the lower court doesn't have the integrity to do the right thing, this will be in the Supreme Court of Georgia. And they will hammer hard on this, because this is the reputation of the entire justice system in Georgia.
Yeah. And so far, the reputation isn't good.
No. It's
just not good. I gotta jump off. I just wanted to say hey and see what was going on and try to answer.
Yeah, no worries. Thank you for being here. I'm about to turn off because I haven't eaten since I got home 6 hours ago.
Ooh.
Yeah.
Time to go eat.
Time to go
eat. Your studio's looking good. You got shelves up there. I see the helmet.
Yeah, everything is starting to form again. I don't know if I will keep this or if I should have floating shelves or something like that to get it completely new. Yeah, and new headphones.
Oh yeah, the new headphones, nice.
Yeah. Oh wait. Oh. Let's see. They have lights.
Oh, nice. You can stream in the dark now and still find your headphones. He can't hear me. We can say anything we want about him right now, and he won't be able to hear anything we just said about him.
Yeah, I'm going to do an OIF motion, and whenever the actual transcript becomes public, because they will send it to the attorneys, I don't think they will hesitate to, here it is. And make it public.
Yeah. Oh yeah, no, that's gonna be made public. That's gonna be an
Yeah.
interesting read. Yeah.
Yeah, and I assume they will do it by the end of today or tomorrow.
The whole world will be diagnosing that transcript and reading through it and finding every little hiccup and syllable said.
Yeah, everything will be, because if Judge Glanville took one last chance and removed things, remember, attorney Kayla Bumpus is no longer under the threat of contempt of court. If she sees something missing, she will talk about it, and she will write affidavits and everything. And the court staff, when they find out, oh, this was illegal, is my career on the... Yeah, this can be interesting.
Yeah, especially being a court reporter, like they're held to a standard. Those court reporters. I had a hearing the other day where the discovery responses that the other side submitted with their response to my motion were notarized, but they weren't signed. And so the judge was like, I have some questions here, because apparently your notary, who has this, kind of the same authority as a court reporter, notarized this without a signature. We're going to be doing some deep diving into this. And what was supposed to be like a 15, 20-minute hearing ended up being a half a day, because they take it very seriously. And so if there's any sort of scrutiny, and this court reporter is not just answerable to this one particular judge. So it'll be interesting.
Yeah, I can't wait for the transcript. I will do live reading tomorrow. I mean, I still have... If I will be mad if this shows up when I'm at work, because then everybody will have done it before I have.
You're just going to need to get a sick day. You're just going to be like, oh, all of a sudden I have the flu, and go home.
I can't. I do have...
Just pour a glass of water in your face and like start crawling and be like, I can't, I got to go to the hospital.
Yeah.
Just hopefully no one from work knows you stream.
Yeah. I can't. I have too much to do at work. Yeah. But as soon as I get home from work tomorrow, if the transcript is public, I will stream and read that live, because that will be interesting. Okay.
All right.
Thank
you
you,
all
Dave.
have a good rest of your day. Nicholas, get some food from you.
Yeah. I can't redirect to the lead attorney because he doesn't allow it for some odd reason. But everybody go over there and listen to Kayla Bumpus. I will listen into it as well. And yeah. Thank you all for being here. Thank you for the gifted memberships. Thank you for allowing me to do this, to try to translate what's been going on in this trial and case for over a year. And I said this early on. There's something wrong with this. And then early on in the trial, that judge is crooked. I saw it, and I was right all along. Okay, that's all I have for today. Let's go out with a tune.
Crooked Fanny playing dirty tricks in the courtroom. She always picks, bending the rules. She'd know it, but I won't let her get under my skin. Down in Georgia, where the blues run deep, crooked justice, a secret they keep. But I see through her lies, I see the truth. Gonna make her pay for what she do. Fanny's got a reputation to uphold, but her tactics are shady. Story untold, she thinks she's clever, but I'm on to her game. I'll expose her